you all have an amazing opportunity to affect young people, children, young adults who are in the system of care. We are really excited that you're here participating in the training today. There's a lot we're going to cover today, and a lot of this will be letting you know how much more you need to know. But you can't learn everything in one day, and you don't know what key issues and circumstances are going to be in the cases that you end up with. So this is a taster. It'll get you started. And the Crossroads for Florida Kids is committed to providing the ongoing support that you need to do really effective work for the kids that you're working with. So what we're going to do now is take out your sheets. You did the what do you know sheets. And we will have a handout. Thank you so much, Katie, for coming. She's going to what you call it, this was your kind of pre-test. So we're going to go through it, talk about the answers here are going to give us an overview of the overall system of care. Then I'll talk about ethical obligations, and Jessica Ray will do the presentation on the nuts and bolts of dependency proceedings. So start with parties and participants. And going through the list, which of these people are parties and which are participants? So when I say the actual custodian, that's the person that's putting the kid to bed every night and getting them dressed for school in the morning. Is the actual custodian party or participant? Anybody? Participant, unless they fall into another category, that is party. The child, party. In Florida, children are parties to dependency proceedings. This is critical to what we're working on today. The community-based care agency, that's the child welfare provider, party or participant? Participant. The Department of Children and Families, party. That is the state of Florida acting through the Department of Children and Families. It's state power to remove children from their parents. The foster parent, participant. Guardian ad litem. Guardian ad litem in Florida is a party. It's a very interesting legal construct because the statute creates the requirement that every child be appointed a guardian ad litem. It makes the guardian ad litem a party, and it's a party with the obligation of representing the best interest of the child. And I challenge you to think of another aspect of civil law where one party is charged with representing another party. It's unusual to the best. I'm not familiar with any other concept of that. They're going through a change in the guardian ad litem program about what that means to represent the best interest of the child. So when we started, guardians ad litem were volunteers. They were associated with the court. They were an emissary of the court, like the eyes and ears of the court, to go out and gather information about children and report it back to the court. The guardian ad litem program has been moved out of the Office of State Court Administrators and the courts. They have independent party status. They now have a statewide guardian ad litem program that is funded and run through the Justice Administration Commission, which is where public defenders, state attorneys, regional counsel, and the collateral attorneys get their funding. So they're a separate entity. It's a quasi-legislative judicial entity that runs them. Identified prospective parents, participants. The legal custodian, which is different than the actual custodian. That may be a person who was the legal guardian or had other legal authority over the child. They are a participant. Anyone whose participation would be in the best interest of the child can be a participant. Parents absolutely are parties. The petitioner, if it's not DCF, is a party. Almost always, probably 99.9% of the time, a petition to initiate dependency proceedings is filed by the state, but on rare occasions, private petitions are filed. It happens most often for immigrant children who need to have an open dependency case in order to adjust their immigration status. But it can happen any private person who has information about a child can initiate a dependency petition. And relatives are participants. So I'm going to give you a quick overview of what that looks like in Hillsborough County. As you may know, Florida privatized child welfare, and a system that gave the responsibilities for child welfare to local community-based agencies, all of whom currently are nonprofit organizations. And DCF has contracted out other aspects of that child welfare function. So you have the next two slides on one page in your materials. So the state acting through the Department of Children and Families. And I've also put in here the top person in each agency and contact information for them, because I always feel like the best way to get things resolved, I always start at the top. So you'll know who the top person is. So the Secretary of DCF is Secretary Wilkins. The Suncoast region is runs from Hillsborough, Pinellas Pasco, all the way down to Fort Myers and Naples. I read somewhere that in the winter, the Suncoast region itself would be the 6th largest state in the country, the number of residents that live just in our region. The head of the region is Mike Carroll. He's responsible for DCF in its entirety for this region. For Hillsborough County, the child welfare buck stops with Jan Gregory. They, in turn, contract for two types of services here in Hillsborough County: child protective investigations, and most of the state are done by employees of the Department of Children and Families. In Hillsborough County, they're done by the Sheriff's Department. Hillsborough County Sheriff has the contract to do child protective investigations. On the child welfare side, DCF has contracted with Eckerd Community Alternatives. You all may be familiar with Hillsborough Kids Inc., HKI. It held the contract from the inception. HKI lost their contract at renewal time this past year, and on July 1, Eckerd Community Alternatives became the contracted provider. On the representation for the state as a party is done by Children's Legal Services. That's the statewide obligation to do the legal work in court. And in Hillsborough County, that is contracted to the Attorney General's office. And I know we have some folks from the Attorney General's office. Can you wave your hand if you're from the AG's office? Okay. Bill Navis from the AG's office. And they're responsible, the attorneys that go into court that represent DCF in Hillsborough County work for the Attorney General's office. If you need to know a real basic overview of how things get done in child welfare in Hillsborough County, you have to have at least a rudimentary understanding of what privatized child welfare looks like. It's different in every community. So at the top is Eckerd Community Alternatives. Loretta Shirley is the CEO. And there are two basic components that you'll be dealing with. Case management organizations are the entities that provide the case manager or the social worker that's assigned to an individual child. As cases come in, they're divided up geographically into West Care, East Care, and North Care centers. Each of those centers has two subcontracted privatized agency. So when a child has a caseworker, that caseworker works for one of those 6 entities under Eckerd. The other set of people that you may come in contact with are the licensing, in Tampa they call them family development specialists or adoption specialists, and those are the entities that license the foster parents and do the work to prepare the adoptive parents. And the set of agencies that are involved in licensing are on the other side. So when you have a kid who's in a home and there's a problem or an issue, there's at least 2 people that should be having eyes on that child. Their caseworker, who works in one of these entities on the left, and the licensing specialist for the home. If there's a problem and the kid's not getting enough food, or things are locked, or there's hygiene issues, there's a licensing specialist as well. So those are the 2 sets of entities that comprise the Child Welfare Agency, which is not a party. The state is the party. DCF is the party represented by the Attorney General. These are the people that are providing the services. So they're the key witnesses for the state, but they are not a legal party to the proceeding. They may at times have their own attorney appear in court, but they are participants, not parties to the case. So the difference, parties have the right to file motions and they have the right to be heard. Participants can be heard with leave of court, but they don't have to seek to intervene. Their status as a participant gives them the right to ask to be heard. So that's the kind of the big overview of who these parties are. Just quickly, the term shelter has two meanings in dependency proceedings, B and C. It's very easy to get confused because you say kids in shelter. You need to inquire, are they saying that the child's in shelter because that's physically they're located in a building that's considered a shelter, or is it they're in shelter status? So when children are first taken in, unless the parent immediately agrees to an adjudication of dependency, they're in a shelter status. And only later, if a dependency adjudication is entered, do they become dependent children. There's some legal significance to this. And so it's important, and when people use the word shelter, ask them to be clear what they're talking about so you know exactly what they're talking about. So we think about children, victims of child abuse, and we see campaigns to save the children, and we're rescuing, come rescue children. We don't rescue children. So it's important for us to really understand what's happened to bring kids into care. As Katie told you in her story, right? She's not got abusive parents who set out to be evil to her. It was a very unfortunate circumstance in her home that caused her to not be able to live with her parents. And Katie's story is not uncommon. In fact, it's very typical. And when you look at the most common reason for removal, the number one reason is neglect. Parents incapable of providing appropriate care, whether that's because of substance abuse, mental illness, or other causes. It's parents incapable of becoming to care for their children. Sexual abuse is the least common. It's what we hear about, what we're afraid of. It's horrific when it happens to children. But when you look at the numbers, most kids are coming into care because of neglect. And this is really important because, we think of we're rescuing children. You think of the firefighter coming in and pulling the children out of the burning building. Well, you know what? When they're out, the firefighter is done. What happens to the kid? When we rescue that child from that neglectful family, then what? Are we providing something better? And for many kids, we don't give them something better than we took them away from. We give them something different, and they will tell you, I'd rather be neglected by people who love me than by strangers. So our mission when we're working with kids is to really look at what's happening in their lives and make the system work better for them. Other common, on question 5, major contributors to bringing kids into care: domestic violence, mental health, and substance abuse. It should never be poverty. We do not take children away from parents who are poor. We should be offering services and assistance to keep kids in their family. Okay. So then, real quickly, some of the topic areas that you may encounter as an attorney for kids are reviewed in this true and false. The first answer is true. IDA, Individuals with Disabilities in Education Act. Approximately 40% of kids that are in care have some form of disability recognized by the education system. Most of them are not necessarily getting the appropriate educational services to meet that need. So being aware of that and on alert for that in your work is really important. The second question, children who are pre-verbal cannot be assessed for mental health needs. The answer to that is false. There is a very well-developed field of infant mental health. Children are affected by things that happen to them even before they're born. When they are born, they can be assessed for their mental health needs, and the system recognizes that. There are infant mental health professionals, really good ones in our community, and all kids can benefit from services if they're needed. Immigration. DCF is not allowed to treat children differently based on their immigration status, period. They are required to provide all services to children regardless of immigration status. It is true that there is a special visa status for children who are declared abused, abandoned, or neglected. Special juvenile immigration status. Children must be 12 or older before they're allowed to attend court. That is false. Children are parties. We have this thing called due process. Parties get to be heard in court. They get to be seen in court. And even children who are very young, not only do they have the right to be there, but the judges need to see them there. And I'm not going to say that every child needs to be at every hearing, but a judge can learn a lot from observing even a very young child interact with the caregivers, interact with the other people in the courtroom that may be family members that they're familiar with. So they're parties. They get to be there whenever they want to be there. We have a new rule, a revision to the rules of juvenile procedure that encourages increased attendance for kids in court. And kids will tell you it's really important because they want to know what's going on in their lives and they need to be there. EPSDT is true. It's a Medicaid term. Almost all kids in care are entitled to Medicaid. Medicaid for children is gold-plated insurance. You probably can't buy it for your own children. It is to cover every known condition or defect that can be ameliorated, provide services and support. Lots of our kids are not getting adequate medical care. We can advocate for them to do that. The Medicaid will cover it. Dependent children who object to locked residential treatment are entitled to an attorney to represent them. That is true. They chose not to use the Baker Act law to do this for kids, but if the state is your parent because you're in dependency and the state wants to put you in a locked treatment facility and you object, the court has to appoint an attorney for the child. That's the only real requirement for appointment of an attorney in our system. So every other party in our dependency case, the state has to be represented by an attorney. The parent has the right to be represented by an attorney and will be appointed an attorney if they can't afford their own attorney. The guardian ad litem is represented by an attorney. The child is a party, routinely not represented by an attorney. That's why what you're doing here today is so important. And the last one, false, is the entitlement for community-based services for kids with certain developmental disabilities. Children with developmental and adults with developmental disabilities are entitled to be placed in facilities that provide treatment and care. That's the entitlement. They're called intermediate care facilities for the developmentally disabled. We have a program that allows people to get community-based services, but it's not an entitlement. If we have clients that have those issues, we'll work with you on those. And going back to my original point about why kids come in care and the importance of your work, the research shows that adolescent boys who stayed with their birth families in situations of neglect did better in their overall outcomes than their peers that were placed into foster care. Kids do better with the families, with their family of origin, with people that love them, that care about them. And we're not talking about serious injury, but we're talking about a level of neglect. And a place that might not be safe for a 3-year-old, because a 3-year-old can't feed themselves out of the cabinet, might be safe for a 12-year-old who can take care of their own needs in the family. And on the second one, children experience 3 to 6 month delay in their education and every move they make. So we think we're rescuing kids, we're taking them away from this bad family, and then we put them in a system where we move them and move them and move them. And every time we move them, we create trauma, we create distrust, and we disadvantage them educationally. So we have to be really careful about what we're doing when we're taking kids, saving them, taking them away. Your resource materials, the notebooks you have in the back section, there's a section called resources. I just want to touch on real quickly what's in here. The guidelines of practice, and we're going to talk about ethical obligations a little bit more in depth in a minute. The second piece is called common issues and dependency. These are the common issues that are going to come up. Permanency, home. Who is my home for my forever family? that's one of the key issues that you'll be able to have an effect with. Placement. Where is that child putting their head in bed every night? Where are they living, and what is that situation like? Education. Are they getting it? Is it adequate? Healthcare. And then issues related to their income and other financial resources. So for each of those topics, we've given you a list of questions to think about. Some will be totally irrelevant to your client. Some will be very on point. And then behind that are a bunch of resources on each of those topics that will help you get more information, do your homework online, and we certainly can point you in the direction of other resources. The last piece in your resource section of your notebook is the developmental milestones. If it's been a while since you've had kids, or you've never had little kids, or my kids are little, I'm not so sure about the tweens, this will help you understand where kids should be at if they're healthy and developmentally on target. So your 17-year-old who's functioning at a level of a 9-year-old, you're going to look at where 9-year-olds should be at developmentally. But this will help you understand and help you identify, is your client potentially delayed from where they should be because of the circumstances or because of their health? And it gives some good questions to ask and think about when you're just trying to find out how the kid's doing and how they're going along. So those are resources that will be there for you. There's a lot more. This is a kind of whet your appetite for resources. So, can you tell me what time it is? Okay, perfect. Okay, so any questions about sort of the big picture? It's really complicated, and I don't expect that you'll walk out of here totally understanding it, but you have some resource to go back to when you have questions. Questions? Anybody? Okay. So how do we do this work, right? You know how to represent your clients. Like most of you, I know, represent businesses, you represent adults, you represent government entities. And it's not usually a day-to-day question of how do I do my job. But when people are faced with the opportunity to represent children, especially young children, everything kind of changes and we have concerns about, really what am I doing? So how do we do our work? Okay, it's not done in a vacuum. What you see up here in slides are in an outline form, which I think is easier to read going forward in your notebooks. So the first thing to know is there isn't a set of standards that will tell you how to represent children that you're mandated to follow. If you were in Boston, you would get a book and a contract, and it would tell you everything that you had to do to represent children in dependency. We don't have that, but we do have some good guidelines and resources that we can draw from. You'll hear people debate best interest, express wishes, substituted judgment. How do I represent a child maybe that can't talk to me? And in Florida, we don't have a grand pronouncement from the court that says this is what you do. So what we do have are two things. We have the best interest representation, and this is statutorily mandated and placed on the shoulders of the guardian ad litem. They are obligated to ascertain what the best interest of that child is and convey that, advocate to the court. That's their job. Your job is to act as an attorney under the traditional attorney-client model. Child is your client, you're an attorney, same set of ethical obligations that you apply in all of your other legal work apply to your representation for children. So the rule is very clear. It's the rule on maintaining the relationship with a client operating under disability. Just as if you had an adult client who had a stroke and has difficulty communicating or maybe has cognitive impairment, so too we act on behalf of children as attorneys for children. The ethical obligation is the same. You maintain as normal a relationship as possible under the circumstances. And the comment to the rule even recognizes that even young children, 5 or 6, and certainly 10 or 12, can have positions on what they want going forward. Jessica, who will be talking to you later this afternoon, represents lots of children. I have little children. My 3-year-old is very clear about what he wants and needs. He can convey that, not in terms that a normal client might, but So we have to treat them as normally as possible in understanding what they want. And that's the cornerstone of the work that you're doing. So you are not permitted to disclose anything about your client's disability if you discover a lack of capacity. The rule does provide that you can, if you feel like your client is not capacitated to make decisions, that you could seek the appointment of a guardian ad litem. This is the general rule that applies for everybody under disability. Our kids should have a guardian ad litem already. They may need a guardian ad litem for other purposes outside of dependency if they have other legal needs that aren't in dependency. We can get to that when those issues come up.
But if that during the attorney ad litem's representation, they find a disability or either educational or physical that they believe that needs to be addressed and it's not being addressed by either the community-based care or by any of the other parties.
Okay, and that's a good question. So the question is, what if the attorney discovers a disability, maybe an unmet medical or educational need? And that goes in the same category with everything else that the attorney learns about, which is your duty to counsel and advise, and we'll go through what those duties are. So unless your client is insistent, don't tell anybody. You cannot tell anybody that I can't read. If your client tells you that, that's a confidential communication. You cannot disclose that. But that's not where you end it. You don't say, okay, my client can't read, so I'm just not going to tell anybody. You find out why wouldn't they let you tell. What services could be brought to the kid? And how do you advocate to get them to a position where they can learn how to read? So you don't, just like you're not a mouthpiece for your corporate clients, you don't just parrot what they tell you. You advise and counsel them. And that's what you do in a case where you learn about a disability of your client. We have a set of guidelines to help you understand what the different roles are and responsibilities are when you're representing a child. These are the Florida Bar Standing Committee on the Legal Needs of Children guidelines. They mirror what the American Bar Association has put out and what the National Association of Counsel for Children have put out. I've only put the Florida standards in your resource book. You're welcome to, we have links to the other ones on our website and the resources in the back of your book. But the Florida standards are not adopted by the bar. They are not official standards. They are coming out of a standing committee of the bar. It will help you understand what you should do in different circumstances. There are a bunch of other conferences and standards that people have thought about. So it all goes back to make it as traditional an attorney-client relationship as possible. And importantly, the same duties of undivided loyalty, confidentiality, competent representation do an adult client. So what do we do this for kids? It means you have to explain your role early and often. I am your attorney. Do you know what an attorney means? And you explain at a level that the child can understand. And that means I work for you. You explain the duty of confidentiality. When you're doing that, don't use the word secret. I get to keep your secrets. For some children that have been abused, the word secret is used to hide the abuse. So we just stay away from that term altogether. That means I can't tell. Whatever you say I can't tell, I can't tell. Even if the judge says I'm going to have to go to jail, I'm going to go to jail. I can't tell. And the children will forget this, and they'll forget your role. So every time you meet them, when you're going through your introduction again, what's happening, you have to remind them early and often. And this duty of confidentiality is the key distinction between, and one of the key distinctions, what you do and what a guardian ad litem does. Katie has been fortunate in her position that her guardian ad litem has not had to disclose information that she's provided. But if Katie were to disclose abuse in her current placement, for example, that attorney would have a duty to report. Because she is not Katie's attorney. She's Katie's guardian ad litem. So the only person with whom children have a confidential relationship is their attorney. Bill used the term attorney ad litem. That's a term commonly used. It's a term in some places in the statute. We're trying to move people to use the term child's attorney. It's an attorney. It's that same relationship. What's ad litem? Attorney at law. That doesn't Doesn't add anything to the conversation. The treatise, for those of you eggheads like me who want the treatise on representing children was written by Professor Jean Coe Peters at Yale. She's got some great articles, a lot of her articles, but she wrote the book on how we do this and encourage us again to repeat early and often what our role is. So hopefully a lot of you got a chance to take a look at your case studies and you read about Dawn. So what do you do when your client, you think her position is really inappropriate, right? I want to go home, even though I told you that my stepfather abuses me. What do you do? Right. You have to explain what you would do for any client that's trying to make a decision, right? Explain the matters in a developmentally appropriate manner. Provide the relevant facts and applicable law, right? Who's going to decide? And the judge is going to decide. And what's the basis for the judge's decision? Talk about the various options. What are the ramifications? If she thinks that she can recant the allegations of abuse to go home, what are the ramifications for her in changing her statement about what has occurred to her in the past? What is that going to mean to her? Counsel. And at the end of the day, you advocate as the client directs. So, when you're talking to Dawn about why she wants to go home, what's happening that she's willing to put herself in an unsafe place? What are the alternatives? What can you do to help her achieve her goals without putting her in harm's way? Then at the end of the day, if she maintains that position, that's the position you advocate for. Now, do you have trouble sleeping at night? You are not the judge. The judge is the decider. You are the advocate. And almost always, and Jess can answer this even more, the children we work with are smart, they're resilient, they are self-protective, and they usually have reasons for the choices they make. They may not be the choices that you would make or you would want your children to make, but they make reasoned decisions, and we have to respect and advocate for what our clients want. Mm-hmm.
Well, but can I just say, I represent your three brothers. If you help, I can help you help them instead of putting you back. I mean, you can tell them.
Right.
Like
Okay, so Laura's suggestion is, could you offer to represent her brothers? Because her concern seems to be what's going to happen to her brothers. You can offer alternative solutions. If the problem is your brothers, let's find a way to take care of your brothers. In this particular case, you probably can't represent them all because of conflicts, but you can advocate for them to get additional people. You can try to use the domestic violence injunction to get the stepdad out, because if it's okay for her to be there with the rest of the family. So absolutely, you can offer other solutions that will resolve what her concerns are so that she's not making a choice that could be detrimental to her. Without a doubt, that is your job, is to try to find ways to accomplish your client's objectives. But what do you do? So in this case with Cassian, he's our little guy, where he doesn't want to express an opinion, right? I'm not going to tell you to direct your representation. So you do your best to find out what your client wants. If you cannot, because they refuse or are incapable of conveying to you, then you look at your client's legal interests. And in the concept in the realm of dependency, there are some pretty good guideposts for that. What have they expressed their needs and preferences in the past? Where do they like to go? Where do they like to hang out? What are they, what's they're, a star athlete, and if they move to a different placement, they're going to be incapable of competing for a year. Or what are the needs and interests that they've expressed in other realms? What's going to get the case over most quickly? It's seldom in a child's interest to have a dependency case hanging open for a long time. And then what's the least restrictive or detrimental alternatives? And this guideline is in the Florida guidelines. Will help you parse through trying to find out and figure out what you should be advocating for on behalf of your client. Brian's our client who has cognitive impairment. And he's older, but he's hard to communicate with. So who can you talk to about Brian? Can you talk openly with his guardian ad litem, case manager, therapist? You cannot disclose anything that Brian tells you unless he agrees for you to tell. That duty of confidentiality is absolute, and it's a cornerstone of your ability to provide effective representation for your clients. It can be challenging, but it's your responsibility, and to, again, repeatedly help them understand in developmentally appropriate language that you have that duty of confidentiality. So this can be tricky. So what if the client discloses abuse that is not already known? What is your obligation? Okay, everybody heard about the Sandusky law, Florida's new abuse reporting law? Our response. Okay, Florida for many years has been a mandatory reporting state. That means anyone who knows that a child is being abused has an obligation to report. Everyone, regardless of profession. For people in specified professions, when they call an abuse report, they are mandated to leave their name and contact information. So teachers, doctors, therapists, if they're calling judges, if they're calling in a report, those what we call mandatory reporters are obligated to leave their name. Everyone in Florida has always been obligated to report abuse. What changed in the law recently was what we're calling abuse. Abuse, traditionally, and what dependency means, is by the caregiver, the person who is responsible for taking care of the child. So that's the parent, the grandparent. It could be the babysitter if the kid's with the babysitter all the time. Abuse by a caregiver. Because what happened in Penn State, the abuse was done by somebody who wasn't the child's caregiver. So technically that would not have come under our mandatory reporting law. We've changed now our law. If you see anybody else injuring a child in that way, you're obligated to report to the abuse hotline. So that's general mandatory obligation. But how does that work with you as an attorney for a child and your duty of confidentiality? Florida law is clear on this point. You do not have the duty to disclose. If your client discloses information about abuse and tells you to keep it confidential, your duty of confidentiality maintains intact. And the statutory citation for that is 39.204. So all other privileges are abrogated when it comes to reporting abuse, except for the attorney-client privilege. Now, I'm certainly not telling you that you just take the information and file it away. That's just the beginning of your hard work, is to figure out how to appropriately serve your client. But you don't pick up the phone and make an abuse report unless your client permits you to make that disclosure.
Is that when we pick up the phone and call you?
That's when you pick up the phone and call me, and then I pick up the phone and call Jessica. So it's it's not. It doesn't happen to everyone every day. It can possibly happen, but I really emphasize this to reiterate the power and the importance of your duty of confidentiality. You also have the duty of undivided loyalty, even if your client's cranky, obnoxious, driving you crazy, and everyone else is really nice. The caseworker, somebody you went to high school with, and the opposing attorney, you used to be at the same firm together. Your duty is to your client, your duty of loyalty. And the dependency court across Florida are very collegial places. The same people are in court every day. They're in front of the same judge. They're, professional colleagues. They're sometimes friends. People know each other, and they treat each other that way. When we have child clients that are in that system, they don't understand that what they're observing is professional. I can assure you that when I represented Xerox, if I went into circuit court with my corporate counsel from Xerox standing next to me and went in and gave a big hug to my opposing counsel and sat down next to them and talked to the corporate representative because we're buddies from high school, I would not still be representing Xerox. When we represent kids, we don't come in and hug the caseworker even though they're our best friend. Our loyalty is to our child clients. And I think Jess put it well to me once. Just imagine your client came in and plopped down a $10,000 retainer to hire you. You treat them like your commercial clients, like your adult clients, and keep that in mind. You'll have no problems with this. They are the sole purpose that you're there, and you have to, not just in the work that you do, but in what you display to them, show them that you are their advocate and not there for anybody else. That duty of loyalty means that you may not be able to represent multiple siblings. It may be perfectly okay for those little boys to stay in the home because the abuser doesn't care about boys. And they may be way better off. He may be a great dad to them. That's a different legal position than the girl who's being abused by the stepfather. So going into it, often you may be able to represent siblings, but they may have divergent interests, and your duty of loyalty will preclude you from representing multiple siblings. Zealous representation. For kids, to me the most important part is the number 3. It's the duty to be creative. You're going to hear, especially for those of you that are new in dependency, oh, we don't ever do it that way. That's not the way they do it. It always happens this way. No, you can't. That doesn't work. Nobody's ever been able to do that. Question, ask, come up with alternative solutions. Be creative. And never forget that people will say, oh, well, you're just the mouthpiece. We had a judge who said, kids don't need lawyers because lawyers are just going to come in and say they're going to make a motion to get a tattoo, to do stupid things. You're not a mouthpiece for your commercial clients. You're not a mouthpiece for your child clients. You have the duty to assert their position, but you have that duty to counsel them, to help them make good decisions. Even if what you argue for, you're going to lose, because there's no way the judge is going to send that girl home to that potentially abusive stepdad, the fact that you are there, that you are representing that child and making that argument is itself therapeutic for the child. They're being heard, their position is being advocated, you're taking it seriously, you're making good arguments, even if you might lose. And the child wins just because you're there standing up for them, even if you lose that ultimate motion. So, questions about ethics. What do we do? How do we do it? I think for the most part, you're going to be able to do this fine without concerns, but you always have people to call on to run scenarios by if you feel like you want to check something out. All right. Anybody? Okay. I'm going to turn it over to my colleague, Jessica Ray, with the Community Law Program.
As Robin said, my name is Jessica Ray. I'm an attorney with the Community Law Program. My program has a grant that enables me to represent young teens that are aging out of foster care. So I represent kids that are 13 through about 23, 24, depending on what their issues are. Got to say, the best clients in the world. So let's talk a little bit about dependency cases. We're going to go through it step by step. I know that there are folks in the room that this will seem like old hand to them, but for the new folks, bear with us. Okay, I love starting all trainings with this because this is probably the most complicated chart I've ever seen in my life. Anyone who feels the need to run out the door, just hang on for a few moments. I love just seeing this chart. I love thinking about the poor attorney who tried to create that, how long it took them to get it actually right. But what we're really talking about is a series of hearings in a dependency case. Dependency cases tend to follow this procedure pretty regularly, and we're just going to go through each of those hearings. So let's talk about which hearings we have. Shelter, arraignment, and the shelter review, adjudication, disposition, judicial reviews, permanency hearings, the TPR, and adoption. There are 8 general hearings in a dependency case. And for each of them, we're going to go through some nuts and bolts. In every section of your PowerPoint handout, we're going to go through the specifics of each of those hearings and what you should do to prepare. There's some tips in there as well. And we will fly through this. But before we get going on the hearings, I want to go back to some basics around dependency. I want to talk about the applicable laws, where we get our jurisdiction, the players, even though I know that Robin touched on that, the rights to notice, participate, and counsel, any time limitations, some of the key factors that we're going to go through, and some common issues. So let's start. We are talking about Chapter 39. All dependency cases fall under Chapter 39. The adoptions, however, are stuck in Chapter 63 with domestic law adoptions. Also important is Chapter 409.1451. That is everything that addresses independent living services for kids that are currently in care and kids who have aged out. Not sure exactly why it's not in Chapter 39, but that's where it lives. So I encourage you guys to make sure that you've got access to that statute as well. And you have it in your yellow books. The other issues, court rules, the juvenile rules of procedure, rules of civil procedure, and the appellate rules. One of the things I find fascinating about Chapter 39 and the juvenile rules is they don't match. So if you can't find something or any relief under Chapter 39, take a look at the corresponding juvenile rules and see if there's any wiggle room there, because sometimes you may find something that you can do under the rules that maybe the statute doesn't have. So you may have some room for creativity. The other piece I really think is incredibly important as an advocate in the dependency system is to look at the Florida Code. The Florida Code are the rules of conduct that DCF and its community-based agencies are supposed to follow. It has a wealth of information about what they should be doing at each stage of the case, what they should be doing when a child is placed in a foster home, what that foster home should be doing. One of my favorite strategies is when I go to court and I ask for a specific order and the judge will say to me, well, what's your authority? And I was like, well, it's my understanding that DCF is required to do that by their own regulations. And then the judge will turn to DCF, the attorney, and say, well, what say you? And it's, it's delightful. What do you say? And they will usually say, well, of course, we're going to comply with our statute or our rules. And it's incredibly important if you are going to go after either an order of contempt or an order to show cause, because you need a very specific court order that then you can later prove that's been violated. So incredibly helpful stuff there. Applicable federal law. The big one is the Adoption and Safe Families Act. That was the law that we were all hopeful would stop those horrible stories of foster care drift, where children entered foster care when they were infants, and 18 years later they were still in foster care. They'd been in 37,000 homes, and no one had figured out what to do with them. ASFA was supposed to free kids for adoption, get them adopted, and hurry out of the system. Those of us in the area know it didn't work quite as well as we hoped it would. But that's what it is. The second one is Fostering Connections. Fostering Connections is a fairly new law, but it's got phenomenal provisions about educational stability, relative caregivers, and independent living services. So it's another area that we as Floridian attorneys can really look to for support for some of our arguments. Jurisdiction. We are in our circuit courts. All Chapter 39 proceedings are held in front of our circuit court. Jurisdiction starts when they file that piece of paper, and that piece of paper can be the shelter petition, it can be a dependency petition, or it can be a TPR petition. Florida, in its great wisdom, has decided that foster care is going to end at 18. Everyone who was ready to be fully independent at 18 raised their hand. Yeah. So Florida is unfortunately one of the few states that terminates foster care at 18. What that means is that if a young person is living in a group home on their 17th birthday and they live there all through that last year and they're about to turn 18, even if it's the night before homecoming, their senior year in high school, because most of us were still 18 in high school, that night they pack up all their belongings, probably in a garbage bag, and they go somewhere else. That's what it means. There's no transition. Well, there's supposed to be a transition, but the home ends. At 18, it ends. So they are out on the streets. There are two exceptions to that. One is the extension of jurisdiction. Any young person can ask the court, if they were in foster care when they turn 18, to extend jurisdiction for 1 year. What that does not mean, as I just misspoke, is that they can extend foster care. What it means is they extend access to the court. They can go back to the court and say, I was in foster care until I was 18, I'm entitled to these services, and I'm not getting them. Can you help me get those services? So for 1 year, they still have access to the courthouse. It doesn't mean that they have a placement. It means they've got access to the court. The second one is extending jurisdiction until 21. That is to allow young folks who are going through immigration cases in order to facilitate that while they're getting their immigration sorted out. Just like dependency system can be bureaucratic and complicated, I've heard that the immigration system can also be complicated and bureaucratic, and so sometimes we need a little extra time so that that young person's immigration status can be finalized before we close the dependency case. Again, under that provision as well, the child is not staying in a state placement, it is just the court's jurisdiction is maintained. Our definition of a child is anyone who's under the age of 18, who hasn't been emancipated, and hasn't been married, which usually is a good thing. Okay, Robin talked about parties and participants. This is a great example of where the juvenile rules and the statute differ. The juvenile rules have a longer list of who are potential participants. I think the key factor is, remember, you've got your basic parties, and the court can add whomever they believe will provide valuable information to the case. That means if there's a service provider or a relative caregiver or a non-relative caregiver who can provide the court with information, the court can give them leave to participate. That doesn't mean that if there's someone that shows up in the courtroom and is spouting negative things about your client or is giving information to the court that's not accurate, that this is a great time for you to object to their status as participants and perhaps asking the court to close the courtroom. Everyone with me? I know we're flying. Okay, the right to notice, participate, and counsel. I would really like folks to think about this in a different way. I consider the right to notice the right to know. You get to know that something is happening, right? The right to participate is the right to be present. You actually get to be there. And then the right to counsel is the right to challenge, or like me, because I'm optimistic, the right to change the outcome of a hearing. So the right to know, the right to be there, and the right to do something about it. Robin spoke about the participants or parties. What I find very interesting is who is the only party that does not have a right to do something about it in the hearing? Who doesn't have a right to counsel? The child. So, and the hearing, the dependency case is about the child. So it's just something that we have to deal with in Florida. Kids have a right to be there. They have a right to participate, but there is no guarantee of counsel. It is a huge issue and has great impact. I know you heard earlier from a young person. The right to have an attorney present with you in court can make a big difference about how empowered that young person feels about what's going on in their life. And as I always like to say, at the end of the day, the professionals, we all get to go home. We get to go to our home, we get to do what we need to do, and the kids are the ones who have to live the court decision. Okay, time limitations. This is actually one right that actually belongs to the child. As we go through this training, you'll notice that there are certain timelines that are put in place by the statute. When certain documents need to be filed, when paperwork needs to be submitted to the court, when hearings need to be held. That right is the right of the child. As an attorney for a child, you should not waive that unless that is in your client's best interest and that's what your client wants you to do. There are very specific limitations of when that right can be waived, and it is when another party's constitutional rights are being impinged upon. So if someone didn't get notice of a hearing, the court is going to reset it so that person can get information or prepare for that hearing. However, if someone didn't do what they're supposed to do and the delay is their fault, this would be a perfect opportunity, if your client wants you to object to the continuance or resetting that hearing. Again, time is the right of the child. They're the ones that get stuck in foster care and have to live those decisions. Okay, key considerations. Let's talk about what is really important in dependency cases. The kids. Everyone has had an opportunity to read the hypotheticals? General nodding? Yep, okay, great. We're going to go up through them as we go through the training, and we'll bring those kids back up. Let's talk a little bit about common issues that come up in every single dependency case. Okay, we'll start with permanency. Permanency is a term of art. You hear it thrown around a lot in dependency cases. I think the best way to think about it is, what is the goal of the case, or what is the plan for the child's forever home? When we've done everything what we're supposed to do in the dependency case, where is that child going to be? The second issue that ties into that sometimes is, where is the child spending every night? Where are they laying their head down on the pillow? What is their placement? And that's really where they're going to stay while we work towards whatever that permanency goal is. Another issue is education. Education is a huge issue in foster care cases. When young people become involved in the dependency system, they tend to not only move placements, but when they move placements, they move schools. So one of my favorite interview questions when I'm talking to a teenage client is, tell me a little bit about high school. And my client will often just say to me, well, which high school? And I'm like, well, how many have you gone to? And sometimes kids will say 13. Okay, 13. So one of the things I like to talk about is, there have been some studies that have shown the impact of a lack of school stability. One study suggests that when a child moves from one school to another, particularly during the school year, not over the summertime, that they can lose up to 3 months of their education. So if a child moves in the middle of the semester, the rest of the semester is gone, because they have to catch up, they have to get reoriented to their school system, so they've basically lost a semester. You move them twice in the school year, that school year is gone. Okay, so if a child has moved multiple times throughout their high school career, at some point they're no longer going to school. All they're doing is like going to a building somewhere and seeing a bunch of kids. They're not getting an education anymore. It's a huge issue, so please be aware. And I'm talking about a teenager in high school, but this impacts little ones as well, including kids in middle school and grade school, even little ones in daycare and preschool. It has a huge impact on a child's well-being. The next group I'm going to lump together. The other issue that's very important to watch out for in dependency cases is health issues for kids. We want to make sure that our kids are receiving the health care that they're entitled to, and that means more than just their regular checkups with their doctors and their dentists. When kids start to move from placement to placement, or from county to county or group home to group home, they often lose contact with their providers. And so that means that they don't have a home doctor or a home dentist. And they are being seen by people that may not have their full history, their family history, or their background. And that can impact the quality of care that a young person has. The next bullet is psychotropic medication. Unfortunately, in dependency, we seem to be very good at extremes. We either don't get the treatment that our young people need, or we overtreat them. I'm sure folks remember the stories of the massive amounts of drugs that our kids are on. They are often overprescribed. They suffer horrendous and lifelong side effects. They are drugged. They are overweight because of the multiple drugs that they're on. One of the things I think is important when you are looking at your client's file is to find out if they are prescribed medication, what they're prescribed the medication for. Does everyone know that the child is on all these drugs so that there's no risk of interaction between the drugs? And are those prescriptions appropriate? If you go to a group home and every single client in that group home is on Adderall because there's one psychiatrist there that prescribes every single kid Adderall, that would be a huge red flag. If everyone lines up to the same drugs, that would be something I would start to question. And I see some nods around the room, so I would imagine that we've all seen that. Okay. Placement in residential treatment centers. Those are locked psychiatric facilities. Huge issues for kids, particularly if that is the only place that we're sending them because we can't think of anything else to do. Kids should only be placed in residential treatment centers when there's a likelihood that they're going to make progress, and they should be making that progress within 6 months. It is not a warehouse and not a place where we should be holding kids until we can come up with something else. We also want to watch out to make sure that our clients, if they have any disabilities, that we've applied for benefits if they're entitled to them, and that they're getting the services they need in order to make the most progress that they possibly can based on whatever their specific disabilities are. And that's the same thing for kids that have been diagnosed with developmental delays. Safety and well-being. Sounds common sense. You know, we want our kids to be safe. We want them to be doing well. But well-being includes more than just, you know, are they getting their meals? Are they doing okay in school? Well-being means, are they having normal activities? Well-being means soccer and swimming and Girl Scouts and math club and chess club. It means the opportunity to participate in regular, normal childhood activities. It doesn't mean that when you go into foster care that suddenly you get picked up out of your life and you get access to nothing else. An important part of being a child is having normal childhood activities so that you can learn how to be a good adult. Kids in foster care deserve no less. Family and friends, the folks that are important to our young people may not necessarily be who we consider family members, but family comes in all shapes and sizes. It's very important to ask young people who they consider to be their family, why, and who their friends are, where they are, what kind of contact they want with them, and to make sure we do our best to preserve those contacts. Finally, income and assets. Sometimes, but not always, our kids will come into the system either with income from a trust fund, a retirement account from a parent, or they may be receiving benefits because they're disabled, a parent is disabled, or there's been a death. It's very important as an attorney for a dependency client to make sure that we are preserving those assets and making sure that they're being used in the appropriate manner, including sometimes saying to the department or their community-based agency is, we don't want you to take that money to pay for the child's cost of care. We want you to conserve that so our client can get access to special services or perhaps save them until they age out of foster care. On the other side of the chart is a list of laws. Now, the reason why these are important in cases is something that I want everyone just to think about when you pick up your case. The first one is the Indian Child Welfare Act. If a child belongs to a federally recognized Native American tribe, they are entitled to some specific legal protections. That means that the standard that is held in certain hearings is going to be different based on that status. It also means the participants in that case are going to be different. The tribe has to be invited to participate in the hearing and can in fact apply to the court to move that hearing into their own jurisdiction. If ICWA is not followed, it can undo an entire case. So one of the very first questions is there any Native American heritage in this family? Please don't assume, unless you're an expert on federally recognized tribes, that you understand what it takes to be a member in a tribe. Each tribe has their own criteria of what makes a member a member. So if you don't know, ask. The state will send out letters to the identified tribes to get feedback from the tribes to understand where they should go next. Uniform Child Custody Act. Want to make sure that you advise the court of any other competing court hearings that are going on. Dependency is sometimes a sneaky tool used by folks in domestic cases to either win something or lose something. Sometimes a dependency case is really a domestic case. Sometimes a domestic case is really a dependency case. You want to keep your eyes open to make sure that you're not having competing orders. What will usually happen is the domestic law case will join the dependency case under a unified family court. Interstate compact on the placement of children. Because this is dependency, we can't do anything easily, so we now have the ICPC. This covers when we want to send a child from one state to another state. It is put in place in order to prevent states from dumping children in other states. That usually, when we find out that that has happened, is when something horrible has happened to a child. Either the child has died or there's been some horrific injury. What this is if we want to send Johnny to his grandmother in New York, Florida says to New York, we have Johnny's grandmother's in New York, can we send Johnny to his grandmother? New York says, well, hold on 1 second, let's run out and check Grandma's house. New York goes out, checks Grandma's house, says, Grandma looks pretty good to us, you can send Johnny. Florida says thank you and sends Johnny. Johnny goes up to New York. Florida may or may not send a case manager out to check on Johnny periodically, depending on what the situation is. So not super simple to send a young person out of state, but not impossible. The ICPC is, again, another piece of bureaucratic hoops that we have to jump through, so it is not the most speedy process. There are some new provisions that allow us to speed up kids in certain cases. It can be done, but it is something that we have to wend our way through.
Question on venue. In that situation where Johnny goes to New York to live with his grandmother, does jurisdiction transfer to New York, or is the Florida case stay open?
That's a great question. Does venue change, or does New York in that case pick up jurisdiction? The answer is Florida maintains jurisdiction. The child's cases continue to be reviewed in Florida until the case either closes permanently, or if for some reason New York says, well, we have jurisdiction because actually what happened is mom abused Johnny in New York, grabbed him, we had a dependency case, and she absconded to Florida. Somehow you guys found him and opened the case, but we already had him. Then there could be some negotiation. But if the factors were just the one I explained, Johnny came into care in Florida, grandma just happens to live in New York, Florida's going to maintain the jurisdiction.
And it'll just be like a placement.
Yes.
In Clearwater, it says placement in
New York. Yeah, absolutely. Special immigrant juvenile status. This is one way that a young person who does not have legalized status can seek to get his immigration status approved or regularized if he's in foster care. The requirement is that the child is in foster care, has been abandoned, abused, or neglected, and is likely to remain in foster care. Reunification is unlikely. It is not the only method for regularizing a child in foster care's immigration status. It just happens to be one of the common ones. It's something to be watching out for, and I think Robin talked a little bit maybe in her presentations that's the other thing you're going to check is, can I see the child's birth certificate? Where is it? Where was this child born? What is the child's nationality? So we want to make sure that we're on top of that. McKinney-Vento is a federal law that deals with homelessness. Where it comes into play for youth involved in the foster care system is it addresses educational stability. If a child is in a shelter, they are entitled to seek transportation back to their school that they were originally at. There's also transportation provided for kids who are awaiting foster care placement. What awaiting foster care placement means is kind of up in the air, but it's certainly something that you can argue for based on the facts in your individual case. And IDEA is our federal education law that requires that every child be provided free and appropriate education. Kids who are receiving special education services must receive education services in the least restrictive setting, can't be segregated from other kids unless that's absolutely necessary. And we want to make sure that if our kids are receiving special education, that their school district is following that law. How's everyone doing? Good? Okay. And then, of course, in the bottom, I said any other issue that's important to your client. Sometimes we kind of get trapped up in what's very, very legal and all these kind of glamorous things. But if what is most important to your client is that he gets his teddy bear back from his former foster parent, that is your case. You went to law school. You've got 7 years of experience. Your job is to get Teddy back. Okay. Dependency cases. How do they begin? Someone believes that a child has been abused, neglected, or abandoned. They call the hotline. Folks, does everyone know what the hotline number is? 1-800-96-ABUSE. Okay. When the person calls the hotline, the folks that pick up the phone will decide whether they're going to accept that report. If the report is accepted, they go out and do an investigation. If during the investigation they decide that there is probable cause, and we'll go over that, the child can be removed. If the child is removed, they must file a petition for shelter care, and we go into court. So let's start with our hearings. Probable cause, here are the definitions. The child has been abused, neglected, or abandoned, that the parents have violated a court order regarding the child, or that there is no one there who's able to care for the child. Okay, so now we're at shelter. Here are your nuts and bolts. Your child has been removed because the agency believes that there is probable cause. The shelter hearing must happen within 24 hours. Do shelter hearings happen on the weekend? Yep, they sure do. What will happen is the sitting judge or the coverage judge will hear the shelter hearing. They'll often do a shelter review that following Monday morning in front of the juvenile judge. The purpose of the shelter hearing is, was there probable cause? Sufficient enough to remove the child. Whoever removed the child or filed the shelter petition has the burden of proof, and the court is going to listen to anything that helps the court make its decision. However, if the court is going to deny visits with the parents, must have clear and convincing evidence that visitation is not in the child's best interest. Okay. Court's going to look at whether the child should have been removed, what efforts were made to prevent the placement, where the child should be if the child is removed, what visitation should be ordered, and what services does the child and or the child's family need. I think what's very important is folks think shelter is just temporary. Shelter can be devastating to a client. It is scary. You don't know what's going on. It often happens after some sort of traumatic event. If there is not probable cause and your child client wants to go home, do not concede shelter. If there is no probable cause and your client wants to go home, argue against shelter, argue for services to keep the child in the home. If a child is removed, once a child is removed out of the home, it is a lot harder to get that child back home rather than keeping the child in the home and putting services in place. This is a big hearing. It kind of is very informal. It happens very quickly. It's shocking that kids are there without attorneys, but it has a huge, profound impact on a child's life. Okay. Removal. We've gone over what probable cause is. They're your definitions again. And one of the other findings that the court is going to make is it contrary to the child's welfare to remain in the home. What the court is really looking at is, was removal absolutely necessary? Was there something going on that was so dangerous that the child couldn't remain in the home? Is that removal best for the child? And what are the risks if we leave the child in the home? The contrary to welfare finding is important because it implicates federal funding for the state. If the court does not find that it was contrary to the welfare of the child, the state does not get any federal funding for that case. So again, if your client does not want to be in shelter care, this is a great opportunity to argue that no, it's not contrary to the welfare of the child, that efforts could have been made to keep the child safe and in the home. One of the things I like to look for when I'm looking at shelter petitions, when I've got a client who doesn't want to be sheltered, is why was the shelter petition filed that previous night or that morning? So if they've been working with a family for 3 months, trying to offer in-home services to prevent removal. Mom is doing drugs, she's not participating in her drug treatment program, and she's not taking the kids to school. Well, what happened yesterday that made the agency file that petition? Was there some sort of crisis that happened yesterday? If the case manager is just frustrated and giving up on the parent yesterday just because they had a bad day, that doesn't necessarily mean that the factors have changed. I want to see something different that happened yesterday that changed the story from the day before. Does that make sense to folks? Okay. All right, let's keep going. Here are your definitions of abuse, neglect, and abandonment. If this didn't happen and your client wants to stay at home, here are the definitions that you can use. Okay. Efforts to prevent removal. Reasonable efforts are one of my favorite things about dependency. You want to look to see what the agency did to prevent removing that child from the home. There is an exception that if there was exigent circumstances or an emergency that they run in and grab the child from the home, that's different. But I want to give you an example. A house is on fire. Agency runs in, swoops the child out of the home, and runs the child out of the house. Appropriate, right? House is burning, got to get the child out of the home. Okay. There is a stove fire. Agency runs in the home, grabs the child, and runs out of the home, right? Okay. Not the appropriate response, right? You can go and put the stove out, the fire on the stove out, right? However you do that, put the lid on or flour or whatever it is to make the stove go out. So what you want to do is make sure that the efforts match the allegations. So if one of the reasons why the child is coming into care is because mom is not taking the child to an educational program, for example, you want the efforts to match that. So what does that mean? Should the efforts be that mom is referred to substance abuse counseling? Well, not unless there's some clear link that says that the reason why mom is not taking the child to school is because mom is on drugs. You want the effort to match whatever the problem is in the family. If it doesn't, because someone is just picking from a list of available services, then I would argue that you don't have reasonable efforts. The efforts aren't designed to remedy the situation. The other important factor to consider is there anything that they could have tried that they didn't that would allow the child to stay safely in the home? That is a huge issue. If they didn't think about, well, grandma could come over and stay in the home, or grandma could come over and walk the child to school, that would be something that I would argue, rather than removing the child, let's see what else we can do to make sure that the child could stay in the home, we could remedy the situation while we continue to work on a long-term cure. Okay, placement. If no probable cause is found, child goes home. Or the court can give the agency up to 72 hours to go back and try again. If the court sometimes thinks, look, I don't see probable cause, but there's enough here that's making me nervous, the court can say, go back, come back in 3 days and let us know what you have. Okay. If probable cause is found, the court is going to shelter the child. I heard Robin talk to you. Shelter can mean the physical shelter, but it is also a legal term of art. It means that the child is sheltered in the care of someone under the custody of the court. So here is where a child could be sheltered. A child could be sheltered with a parent. A child could be sheltered with a grandmother. A child could be sheltered in foster care or in a group home or with a family friend. A child could be sheltered in a shelter. Okay. Sheltered is a term of art. Once a child is under a court order of shelter, you can't take the child out of that shelter. So the case manager can't go and say, well, yeah, it wasn't as bad as I thought it was. I'm just going to pick him up and take him home. Can't do that. They've got to bring it back to court. Okay, considerations. When we are talking about where a child should be placed, there are a couple key considerations. The first one is safety. The child has got to be safe wherever we're going to place them. We're not doing our jobs if we remove children from a situation that we say is unsafe and we put them somewhere else which is equally unsafe. Might as well leave them with the people that they know, right? The second is placement should be least restrictive and stable. If folks will cross out least restrictive and write most like their home. What that means is when a child is removed from their placement, they're supposed to be placed in something that looks as close to their family setting as possible. That usually means it's going to be in a foster home, but it also means that their placement shouldn't be 400 miles away or in a different neighborhood. Unless there are safety issues, the child should be as close to their neighborhood, their school, their wherever they go for their religious services, their after-school activities, their siblings. It should be most home-like as possible. That also brings up the next point, is that siblings should be placed together. And they should be placed together unless there is a safety reason why they cannot be placed together. A good reason for not placing kids together is not that they couldn't find a foster home that would take them both. Right? The siblings are to be together unless it's not safe for them for some reason for them to be together. There's a preference for relatives or relatives of a sibling, also family friends, people that are known to the child. Caregivers should be made aware of the issues that the child is facing so that they are adequate caregivers, able to meet that child's needs. If a child needs specific services or medical care, we want to make sure that whoever the child is placed with is able to meet those needs. The next one is there a good cause to request an evaluation? I want everyone to star that. Sometimes folks are proposing a caregiver that your client might not want to go with. And one of the reasons is they'll say, look, you're taking me away from my mom because you're saying my mom smokes marijuana. But now you're recommending that I'm getting placed with my aunt. Well, my aunt smokes marijuana. I don't want to go there either. I'd rather go to a family friend. So if there is good cause, you can make an argument to the court that the proposed caregiver should submit to a substance abuse assessment, random UAs, or an evaluation. And once you ask that, the court is going to look long and hard at what other options you might be suggesting for your client. Limitations, again, we've got a time right for a client. They should not be sitting in shelter care for years. Robin, did you tell your story about the young person? Okay. Robin was aware of a young person that sat under a shelter order for 2 or 3 years. 4 years? 4 years. That is not okay. It has implications on what benefits that young person is entitled to, but it also means that we're not doing our job in finding that young person permanency. So 60 days without an adjudication of dependency, 30 days after the adjudication. Okay. When should visitation be ordered? Every time. Visitation is the right of the child. It should be ordered every time a child is removed from the home, unless there are safety issues. Remember, the standard for denying visitation is clear and convincing. The department is required to make a recommendation of what their visitation should look like. If there are allegations of sexual abuse, there is a part of the statute called the Keeping Children Safe Act. The court has to comply with that. Visitation should commence within 3 days, but I think it's really important to think about who else your client needs to see. It's very easy to say, well, we want to set up parental visitation. But if siblings have been separated, it's important to think about sibling visitation. If the children come from a home where maybe there are a couple generations of families living together, think about cousins or other kids that were in that home. It's also important, if there are people important to the young person, their well-being, to make sure that that visitation includes. If you are representing a teenager, if there is a significant other or a best friend or a family friend that's important to that young person who provides support for that young person, we don't want placement in foster care to cut off that support. It's sometimes the one thing that will keep our young person okay while we figure out the rest of the case. Okay, the intent is that children should have regular visits with their parents. It says once a month. That is not adequate. And regular visits with their siblings once a week. Again, probably not adequate, but certainly a minimum that our kids should be seeing each other once a week. Big issue at shelter and at every hearing: what services does the family need? What services do our clients need? Again, we talked about education. We want to make sure that if we can keep our child in the same school, unless there are safety issues, we make every effort to do that. We want to make sure that the court has ordered any assessments or treatment or medication issues that are brought up in the shelter care. If they are considering placing the child in the residential treatment center, you want to have an opportunity to talk to the person that did the assessment before the court makes a decision about whether the child should go into a a residential treatment foster care placement. The other piece is we don't have to wait for the next hearing to start talking about what services can bring the child back home. It is never too early to start providing reunification services to a family. If we can do something that will enable the child to get back home in 30 days, let's do it now. We don't have to wait until we go all through the process of the case to begin those services. The big piece I put down there is the child eligible for a CBHA. A comprehensive behavioral health assessment is a comprehensive behavioral health assessment of the child. What it is, it looks at all the needs of the child and makes recommendations. Once the CBHA is ordered, the agency has 30 days to implement those services. It can be incredibly telling because the person that does the assessment gathers a lot of background information, speaks to relatives, to the parents, to providers, and will give a lot of insight to the case. It's a great document to review. If you pick up a case further along in the case, that's one of the first documents that I always go back through the file to look for to see what it said about what was going on with my client when they came into care. Okay, I put a list of local practice questions that I think is important for you to talk to your local experts about that could implicate the local practice in Hillsborough County. I think it's very important to know that even though we are operating under a statute and a set of regulations, that obviously each jurisdiction is going to have their own habits, trends, what they do. Just consider those. Okay, I gave you some tips about how to prepare for shelter hearings. I would imagine in most pro bono cases, you guys are going to be picking up pro bono cases that are well past this stage. I've given you a couple slides. Okay. Oops, sorry, went too fast. There are required content from the statute of what a court order should contain, and we've gone through the list of things that you should consider asking for. Again, you're going to talk about educational records, what's going on with the child's school. You're going to think about whether there are any needs for medical or health assessments. You're going to think about asking for services. You want to find out if there are any relatives. You want to ask the court to order home studies on potential other placements. You want to ask for an early review if there's something that you want to come back and bring back to the court immediately. And the second to last bullet, if everyone will star that again. Another secret tool, there is a Chapter 39 injunction. If you need something to happen in a case, you need mom to vacate the home so dad can stay in the home with the children, you can use a Chapter 39 injunction to ask the court to order that. It is a tool that I don't see used very often. It's certainly something that I think we should put in our stash of secret weapons. You can also ask the court to order that the mom who's vacated the home is contributing to the mortgage so the child doesn't have to go into foster care. It's a tool. We don't use it enough, but it's certainly available to us. Okay. After every hearing, I've given you a list of next steps and what to expect as you prepare for the next hearing. So now we're going to move on to the arraignment and shelter review. But before I do that, anyone got any questions? Okay. All right. Arraignment, 28 days after the shelter hearing, 7 days after the dependency petition is filed. And the purpose of the arraignment is exactly what it sounds like, just like in the criminal context. It's the opportunity to advise the parents of their right to counsel, to find out whether they're going to admit, deny, or consent to the petition. The other issue is that the court is going to review the shelter. Clear and convincing evidence still applies for the denial of visitation, and the court is going to listen to anything and everything when they do the shelter review. Okay. Again, are parents going to admit, consent, or deny the petition? I have never seen a parent admit. There's just simply no reason to admit. I mean, so I think that would be bad counsel to advise someone to admit, yep, I did all those terrible things. Oh, and you missed one. Could you add that one in? Rather, what they can do is consent, and what that says is, look, there's enough in the petition that suggests that perhaps our family needs services. We're not going to admit to the allegations, but we are going to be willing to submit ourselves to the court's jurisdiction and work on a case plan. If they deny the allegations, then we set it for trial. The big piece about an arraignment hearing is if a parent has gotten notice to attend the arraignment hearing and does not show up, the court can find that they have deemed to consent to the petition, which in general you think is not a bad idea. We just move on, we go on with the case. Here's the issue, particularly if you are representing older teens. This is the petition. Mommy beat up Johnny. Johnny is a hooligan. Johnny smokes pot. Johnny was out late robbing the local grocery store. Johnny returned home. Mom was really mad. Mom grabbed the belt and beat him up. Okay? If we let that consent rest, that petition becomes the story of the case. And what we know is that no one's proved those facts. But what it does is that just becomes the initial document that everybody reads about the case. And if our client is Johnny, we don't want the petition to say that. So what we're going to be doing is asking the court to, or the agency to amend that petition to say, Mommy beat up Johnny. That's it. We don't want anything else. And if they want to have the facts about that Johnny's doing drugs and he stole from the grocery store, let them prove it. So as the child's attorney, it's very important that just because the arraignment is really about whether the parents are consenting, admitting, or denying that petition, we want to make sure that we're prepared to argue why it either needs to be amended or it shouldn't be consented to that day until we actually go to trial. Between the shelter and the arraignment, the department was supposed to be working on trying to get the child home. We want to find out if they've done any of those services. Have they made those reasonable efforts? Do those efforts make sense? And we also want to check in on where the child is. If they're still in shelter, is that the appropriate placement? Or by now, have we identified relatives or a family friend who might be willing to step up and care for the child? We want to check in on visitation. Sometimes we've now identified other folks that are important to the young person, or maybe someone's come up and said, Johnny used to come to my math club every Wednesday, and all of a sudden he's not here anymore. What happened? And then we find out that maybe this is someone who's a resource for Johnny, or maybe we want to have a service in place that says that Johnny gets to go back to that club. So it's a great place to check in on your child. again, got some local practice questions. Again, talk to your local experts about those. Some preparation tips. We've got your required content of your court order per the statute. Remember, you're going to be looking to see whether you need to ask for any amendments. Think about if there are any services that could have been in place or could be put in place so your child could go home if that's what your client wants. If there's any issues about the current setting of the child, if we need to change the shelter placement, are there any needs for services that we could ask for ordered? Sorry, I said that completely wrong. If there are any services we need to ask the court to order, and if we've gotten any more information on relatives who may be a resource for that child. Okay, got your tips for next steps, and now we move on to adjudication. This is what's going to happen if the parents have denied the petition and are seeking a trial. We're going to have this as soon as possible, but no later than 30 days after the arraignment. And the purpose of this is just to have a trial on the facts. Are they true? Do they support a finding of dependency? Dependency is proved by preponderance of the evidence unless the child is ICWA. If the child is part of a federally recognized tribe, the standard is different, and you're going to be looking for clear and convincing evidence. But hold on, let me just check that to make sure that I'm correct. Yes. Okay. Again, we've got the same clear and convincing rule for denial of visitation, and the rules of evidence do apply. It is probably one of the only hearings, other than the TPR hearing, where rules of evidence apply. So those of you who practice in other courtrooms, welcome to dependency. It can be a lot of fun, but these are the two hearings where the rules of evidence actually do apply. Sorry, I want to go back quickly. Anonymous calls must be... there must be something more than that. If you have a horrific phone call into the abuse hotline that says, child horrifically abused, covered with bruises, if that's all you've got, you don't have enough. Okay? The basic consideration, is the child dependent, and where should the child remain? Okay? Dependent child, here are your statutory definitions. Basically, what we're saying is this is a child who needs the court's assistance in order to make sure that we either be able to send the child home safely or come up with a different family situation for that child. Dependency. Dependency is a finding that is actually placed on the child. It doesn't need to be found against both parents. It can be on one parent, both parents, and the court needs to find out whether each parent is responsible for the abuse, neglect, or abandonment. If, after you have an adjudication trial, the court finds that the child is not dependent, the child goes home. That's it. The dependency is the hook that enables the court to maintain jurisdiction over the case. If the child is found dependent, but the court says, yeah, there's enough here, but the child can go home with services, the court can say, well, we're not going to, I find the child dependent, but I'm going to actually withhold that order, and the child can stay in the home, we'll withhold the order of dependency, and we'll provide services. If the parents don't comply with the case plan or don't comply with the court order or get removed, then the court can just say now the child is dependent. They don't have to go back and relitigate the issue of dependency. However, if the child is not going to be placed in the home and is getting removed, the child has to be found dependent. There's going to be no withholding. If the child is out of the home, they're dependent. If the child is staying in the home, they could be dependent or the court could withhold the dependency. One issue that's important when you come into cases later on, if the child started out remaining in the home and then was subsequently removed, go back and make sure that your court made that finding of dependency. Because if they originally withheld the dependency, then the child was removed, you want to make sure that they changed that finding and did find the child dependency. We've just found a couple cases where that didn't happen. It's sort of an oversight, but you want to make sure that that's in place because later on it's important for other services that the child might be entitled to. Okay. Where should the child be placed? The same factors that we considered in the shelter hearing. Safety is paramount. Placement must be least restrictive, most homelike, and stable. We want our SIBs together. We want them with relatives or people they know if all possible. Again, we've got the opportunities to ask for evaluations of caregivers if we need to. Here are some issues that you should talk to your local experts about local practice. Okay, here are your tips for preparing. Let's talk a little bit about Dawn. Folks see any issues with Dawn? Because we're right around the adjudication disposition phase for Dawn. Any facts that are jumping out in regards to this case? Concerns? Questions? Did you?
It appeared perhaps an injunction would have been appropriate to protect your sibling, confidentiality and potential consequences of perjury if she were to retract it.
Okay, so a potential injunction, maybe to keep the other sibling safe, maybe to get the alleged abuser out of the home and maybe stay with mom, if mom was willing to do that or in agreement with that. Also issues about advising Dawn about perjury or what happens if she changes her statement. Are there any other concerns that come up in this case?
I put some mental health issues, perhaps with her ambivalence of going back and forth with the story, but also losing control of her temperament and whatnot.
Exactly. So there may be some mental health issues. Dawn is having a hard time deciding what her position is. That she is getting very loud, maybe losing her temper. What other issues are coming up in this placement? What is Dawn frustrated about?
She lost touch with her school friends and having a telephone access.
She has no telephone access. She lost touch with her school friends, which means what? She probably changed school placements. So we have already lost one piece of stability in her home, and now we've made her lose another one. And some of the things that she's talking about seem pretty typical for teens, right? She wants access to the things that are normal to her. Okay. All right. I think that's good. We'll keep working on bringing up some issues. Okay. Here are the required content, list of required content for the order. Remember, at this hearing, we can again ask for amendments on the petition. Look to see if there are services that could get the children home, if that's what our clients want. Look to see if we've got any relatives. Make sure that if there are any relatives that want to be informed about the process, that the state is doing that. We want to find out if this was a time that our client now has identified other places that they could be to ask for a change of placement. And again, the fabulous need for injunctions. The very last bullet is one of my favorite things about Chapter 39. We can ask the court for any other order necessary to protect the health, safety, well-being of the child, including diagnosis, evaluation, treatment, and visitation. Huge star. This is, I like to call it this is my Jess, what do you want provision. Okay, here are your next steps. For both after the hearing and to prepare for the next hearing, which is the disposition. Okay, this is going to be held 15 days of the arraignment if everyone consents or admits, or within 30 days of the adjudication hearing. We're going to be looking at what are the most appropriate services and protections for the child and the family, and to take a look at the case plan. The department has to show that they've made reasonable efforts to get the family reunited, and the court is going to look at a predisposition study, which is basically the department's story of the case, and find any other relevant evidence, or consider rather any relevant evidence in making a decision on what's best for the family. Okay, let's go through the basic considerations. Case plans. The case plan is going to be the roadmap for the case. What it is, it's a list of all the factors that brought the family to the attention of the department. And there's going to be a list of services that are supposed to remedy those issues or problems that the family is having. What you want to be looking for is making sure that those services make sense based on the allegations. So again, if mom has massive mental health issues and she is self-medicating through the use of drugs, a case plan that says mom should complete substance abuse treatment, she should drop random UAs, and that's the extent of it, is not a sufficient case plan. because we all know that if mom has got underlying mental health issues and we don't provide services that enable her to address that, even if she does get clean, her ability to remain clean is going to be in serious jeopardy because we haven't addressed the underlying issues. So case plans have to make sense, and the services provided by the agency must match. The case plan is not a tool that you can be used to hold over the parent's head. It is supposed to be something that remedies the case. If the child has had a comprehensive behavioral health assessment, we should be taking a look at that to see what other services should be put in place, both for the parents and for the child, to make sure that what we're doing is trying to make this family better so that they're able to be reunified in a safe situation. Parents don't have to sign the case plan without their attorney. They can have their attorney take a look at the case plan. The parties are supposed to get together to develop the case plan. However, there is usually one participant or person who is not often at the case planning conference and drafting the case plan. And who do we think that is? Yeah. So once again, the child is often not included that. If we're involved in cases at this stage, we should be at the case planning conference. We should be advocating for what should be part of the case plan. The way that I talk to some of my clients about this is, if your mom or dad does all the following things, would you be okay to go home? And if my client says no, because mom should do this as well, or yes, but mom needs to do this, then that's when I advocate for those additional services. Because if our clients want to go home, they're not asking just to go home for the weekend. They really want to go home and stay home. They want to get out of Dodge. They don't want to be involved in the dependency system for longer than they need to be. Again, must be meaningful and designed to address the facts that led to the involvement in the dependency system.
Excuse me. Are there any statistics available to show the success rates of those case plans when those kids go back to their parents?
Okay, the question was, are there any statistics available to show how successful the case plans are? The answer is sort of. And the reason why states are required to track re-entry into care. When a child comes into care, is reunified for a parent, and then comes back in, states do provide data to the feds about the rate of re-entry. However, the ability to tie that to the successfulness of the case plan, I don't think they've made that link. What we know is when parents get meaningful services and adequate support, they tend to do better. Whether the case plans facilitate that probably depends from case manager to case manager, local agency to local agency, and the actual service providers that are out there. In some jurisdictions, the scarcity of well-qualified providers make it very difficult for families to reunify successfully. Even though everyone has really good intentions, the parents are working the case plan, the case management is working the case plan, but if we don't have the resources available, that can make reunification very, very tough. Sure.
I just, every Monday, Eckerd puts out they have a data call that talks about how they're doing here locally, and I received today's data. Hillsboro's got a much higher re-entry rate than the statewide average. So this is an area that we really need to work on. Our kids are in longer and they're coming back faster than their counterparts across the state. So getting the right services and making sure that it's the right thing that the kid needs to stay home safely is really important here in Hillsborough County. It's an area where we're behind.
How often are parents actually represented by counsel?
I don't know the statistics for Hillsborough. I would say regularly, in almost every case. Parents are entitled to counsel in dependency proceedings. If they cannot afford counsel, counsel is appointed for them. Yes. And for those of you who are saying, well, that's odd. A parent who has abused or neglected a child gets a counsel and the child who's been abused or neglected doesn't. Here. I agree.
And sometimes they're not justified to begin with.
That's exactly right.
You know, the state doesn't always do a sterling job.
Absolutely. The state clearly does not always do a sterling job. I think that there is a wealth of room for improvement. Absolutely. Let's talk about placement options. A child can be placed with the parent from whom they were removed. The court will often order conditions of placement, what needs to happen in that placement. But if that happens, the court is not going to close the case out. What they're going to say is, we're going to monitor it for a minimum of 6 months. It doesn't mean that it must close at 6 months, but they have to monitor it for at least 6 months. The child can also be placed with the non-custodial parent. Sometimes they're referred to as non-offending parents. I think we've got to be really careful with that term of art, because as a parent, you're responsible for the well-being of your child. If you're not involved that much with your child that you don't know that something terrible is happening to them, I'm not sure how non-offending you are. Non-custodial is probably the cleaner way to describe that. The child was not in your custody. The court is going to require that there be a home study on that non-custodial parent, that there's no danger, and that the placement is in the child's best interest. If the court decides to grant sole custody, what they could do is then say, we're going to terminate jurisdiction, but before we do that, we're going to address visitation with the offending parent. The custody subject to the court's jurisdiction could require that the parents get services, and the court is not going to go back in and change custody unless it's a determination that such a change would be in the child's best interest. Everybody with me? I kind of flew through that. Those are with the parents. The other placement options are with an approved adult under temporary legal custody under the department's protective supervision. Approved adults can be any other adult, an adoptive parent of the child's sibling, or another adult who's gone through to the agency and done a background check and who has done a home study. The agency is not going to look to close out that case with that person until that child has been there for 6 months. That being said, if there's a non-relative or a relative that steps forward to care for a child, and they go in and they get their fingerprints done, and there is something negative that comes up on their home study or on their fingerprints, the agency might say, we are barred from approving this placement. However, as the child's attorney, if the child wants to go there, you are not done. You can go to court and ask the court to overrule the agency's denial. What you need to prove is that the person has rehabilitated themselves or there's no danger to the child. The facts are obviously going to be very specific. If you have someone who recently murdered someone, particularly a child, you should probably advise your client that this is not going to work. Okay. However, if the client says, look, I want to go with my neighbor and he has a long drug history, but he's been clean for 7 years, he's working, he's now a mentor at my local high school, and when I get into trouble, that's where I go. In fact, he's the guy that called the police and said, my mom's beating me up. That might be the perfect placement for a teen client. And so what you want to do is take that in front of the judge and advocate why this would work best for your client. I've got to tell you, people even with backgrounds that may not look perfect for us can be incredible resources for our teens. And our younger kids. And it is sometimes so much better than placement with either a group of kids in a group home or someone that's not known to them in the foster care system. So don't rule out that option. Maybe you want to start that one as well. Finally, a licensed foster care provider. Once a child is placed in licensed foster care, that can either be a foster home, a treatment foster home, a group home, or a treatment group home. Those folks don't do a home study because presumably they've already done that when they went through the licensing process. What's important about this type of placement is once a child's in foster care, the agency doesn't have to come back to court when they move them from home to home to home to home. So it's very important to be aware of that is the type of placement. It's not the foster home of Mrs. Smith. It's foster homes. So if he's with Mrs. Smith and Mrs. Smith says, I can't tolerate him, he could go to Mrs. Williams and then go to Mrs. Frederick. He could move from multiple placements. There's no requirement that they come back to court before they change that placement. However, if he's placed with a non-relative, Mrs. Smith, if Mrs. Smith says, I can't care for him anymore, you are going to come back to court. Okay? Make sense? Okay. Placement changes can happen anytime after the disposition. You don't have to go back and relitigate the issue of the child being dependent. The child is dependent. The court has jurisdiction. Anyone can go to the court and say, we want a change of placement, including the child's attorney or the child. If the parents or the legal custodians disagree with the change of placement, the court's going to hold a hearing. Sometimes everyone's going to be in agreement. The court will sign off on that placement. The standard of deciding whether to change the placement is whether that placement change is in the child's best interest. The court should be looking at stability as well, but often if we're looking to remove a child out of foster care into a placement that they know, the court is going to take that more seriously than the fact that the child is now moving to another placement. If the court is looking to move the child back home, the court is going to want to make sure that there is some sort of substantial compliance with the case plan, that the parents have done enough that it's safe for the child to go home. The second to last, and actually the last bullet, is children with extraordinary needs and group homes. Believe it or not, in our statute, there's a provision that says if a child starts to move around quite a bit, that the agency should consider whether it's more appropriate to place the child in a group home, which is funny because group homes generally aren't the best place to place children. But if your child is being evaluated for a group home, you want to be part of that meeting, part of that assessment. Unless your client wants to go there, if they're doing okay in a foster home, you want them to try everything before they go into that more restrictive setting. We are not raised, human beings don't get raised in groups. We're raised in family-like settings. And so group homes are not a normal placement for kids. And the outcomes aren't great. RTC placements, residential treatment centers, they're often referred to as SIP, SIPP, statewide inpatient psychiatric programs. If a child is being referred to as SIP, there needs to be an assessment that says that the child needs that level of placement. As a child's attorney, you have a right to talk to the assessor before they do the assessment and to review the assessment before you go to court so that you're able to argue about whether that's appropriate or not. The child should not be going into a SIP placement unless it's likely that they would actually benefit from that. So if you have a child that has a lower cognitive level and is unable to benefit from the services of a SIP placement, that's not the place to place them. We should not be warehousing our children. This is my what does Jess want order. There's your site, Chapter 39, 5211D, sub 9. Again, this is a huge secret weapon. I know I've been asking you to do stars, now do little hearts all around this because this is an incredible order that you can ask for at any post-dispositional hearing. So anytime your client needs a service, needs some visitation, needs something, and the court says, what is your authority? You say it's Jess's law. No, you don't say that. You give them the site, 39, 521, 1D9. Okay. Again, at every hearing, you're going to be asking the department about what reasonable efforts they made to reunify the family. What did they do? Are there efforts specific to this case? Are the efforts likely to be successful? And are there any issues about what's going on in the case plan? If they're not going to make efforts, why not? And if they're not going to try to work towards reunification, should we consider whether we should be looking for something else, like terminating the parental rights and finding another plan like adoption for the child? Again, this is very important that you know what your client's position is, because just because mom and dad aren't doing anything doesn't necessarily mean your client wants their rights terminated. They may want mom and dad to be mom and dad. They may just say, look, I'd rather just stay with my friend, but I don't want mom and dad not to be mom and dad. So just because the parents aren't doing anything doesn't necessarily mean that we're, as the child's attorney, are going to jump to adoption unless that's what our client wants. I also think this is a great place to watch for templates and generic language about reasonable efforts. The effort should be specific to the case, to your family, and to your child. One of my favorite reasonable efforts ever that I saw on a list was the child was attending school. And I'm still confused about why that's an effort. I wasn't sure who was doing what to make the child attend school. It had nothing to do with why the child was in foster care, and it's required by law. It's sort of, my other favorite one is, the child is breathing air. Okay, yeah, that happens, but it's got nothing to do with remedying the case. Another great sign that perhaps reasonable efforts have been cut in place from another case is if there are things going on in the list that never happened in your case. So watch for cut and paste, watch for efforts that are very generic, kind of selected from a grocery list, but not actually what's going on in your case. The efforts in your case should be specific to your family. Okay. Here are some questions about or local practice issues that you want to consider, your preparation tips, and let's talk now about Eddie. Folks got concerns about what's going on with Eddie? Okay, where is Eddie living? Eddie's our little guy who was with Dad, then Dad got arrested, went to jail. Eddie's now in foster care. Anyone see any issues with Eddie that they're concerned about?
He's spending 3 nights with Dad, and Dad doesn't have the accommodations for the child to be well taken care of. I mean, there's no toys that you might have to there's someone to live in a room who goes to work sometimes, so obviously it's not an environment where the child can thrive.
Okay, so there's some issue about, or some concern maybe about whether placement with Dad is in Eddie's best interest or where he's going to thrive because there are no books, there are no toys, and there's some concern about the babysitter, about when Dad's going to work. If Eddie wants to be with Dad, how do we help fix that? Yeah, we bring his toys to Dad's house and we talk about finding another babysitter. We get him a referral to another babysitter, right?
Services in the home case plan.
There's we could put service in the home. We can take a look at the case plan and see what's going on. Any other issues?
I have an issue that somebody told him he has to pick between his father and his foster parents.
Yeah, my hackles went up when I read that too. I was like, who's talking to my client? Who's telling him what his options are? That's what we're there for, is to advise him and say, look, we're going to court, and the judge is going to be considering whether you should go home with Dad or stay with your foster parent. I'm here to talk to you about that and find out what he's saying. We don't know why Eddie's confused or scared about picking. Maybe Eddie's just a really sweet kid and he really wants to go home with Dad and he doesn't want to hurt his foster parents' feelings. Maybe he doesn't want to hurt Dad's feelings because he really wants to stay with his foster parent. Any other issues?
Where's his mom?
Yeah, I think that's a huge red flag in this. We don't know what happened to Mom. We don't know where she is. We don't know why she left. There's also something else we don't know at all about the parents as well.
They're even married.
Or if they're even married, that's true. Why was he arrested? We have no idea why Dad was arrested. He could have been arrested for something fairly horrendous, or he could have been arrested like one of my client's fathers because his brother used his name. And he was arrested, he was detained. By the time he got out of jail, he had lost his job, so he couldn't pay rent, so he lost his apartment. Like all those things that happen when families don't have resources, that could happen to all of us when we lose our resources. And it took him a long time to get himself back in a position to take his client back, or his child back. In front?
It wasn't clear from the fact pattern whether or not he was just released or if he had been incarcerated and served his time.
Right. So we actually don't know
What the disposition of criminal cases.
exactly. So we've got this big question about why was he in jail? What happened when he went to jail? What did he serve time? Does he have something else that he needs to do? Is he on probation? Are there any conditions of probation that we need to be aware about? We also don't know what the case plan should look like because we don't know really what happened, so we don't know how to address what should be going on, right? Okay. And I think the other thing too is it's very clear that this is a case where we need to be thinking creatively about those services. What I find interesting is that if a child is in foster care and has toys, those toys really should be the child's, right? If Eddie got a toy or a bunny rabbit, it shouldn't be something that's tied to the foster home. It should be Eddie's bunny rabbit that he gets to take with him. And so if Eddie's not allowed to take the bunny rabbit to Dad's house, that sort of sends up some red flags to me about what's going on in the foster home, right? Okay. Okay. Required content by the statute. And then again, our considerations. Services. Whoops. Sorry about that. Services to maintain the stability of education, promote family preservation or reunification, where our children are going to live. Do we have any grounds to challenge those reasonable efforts findings or seek a court order to remedy the lack of reasonable efforts? And do we need to ask the court to come back for an early review because we want to resolve some issues? We don't want to wait until the next review. Okay, here are your tips for next steps, both after the hearing and to prepare for the next one. And now we're going to judicial reviews. It is my assumption as pro bono attorneys, if you're picking up a case, that most of your cases will fall in this land. It'll be with kids who have already gone through those first set of hearings, and now they're in the judicial review stage. Judicial reviews. The first review is 90 days after disposition or case plan approval, but no longer than 6 months after review or removal. So if there's been a delay in getting to disposition, it's 6 months after that removal. Then we're going to have the reviews every 6 months. These are the ongoing reviews. Every 90 days if the child is in a SIP or a residential treatment placement, and within 90 days of when the child turns 17, because by that time we've suddenly figured out that after 17 comes 18, and we've got to scramble to get this young person right. The purpose of the judicial review is to review how the child is doing and to check on the parent's compliance with the case plan. We also want to make sure that we're looking about, is the child okay where they are? Are they receiving the services they need? But also, is that case plan adequate? Are we making progress, or have we discovered anything else that we need to modify? The court is going to look at everything. Again, for those of you who do not practice in dependency court, I heard another attorney describe it as Alice in Wonderland. Welcome to our world. Okay, here are our basic considerations. Again, we are looking at, is the child appropriately placed? Again, are they in the most family-like setting, most like home? Are they close to home? Are we working on getting the child the services and supports that they need? Is the child doing well in school? Is the child stable? Are they able to maintain their placement in the school, or have they suffered multiple moves? If that's the case, we may want the court to order that if the child is moved again, that we've got to come back to court and the agency needs to seek transportation to prevent another move. For children that are 13 to 17, we want to look at what services have been put in place to prepare that child to be fully independent at 18. And then for kids that have or receive special education services, is there a surrogate parent? What that means is when a child has an individual education plan that lists out the special education services that the child is needing, there has to be an adult there, either the child's parent, custodian, or the surrogate parent who signs off on the plan and says, yes, I'm in agreement with it. This seems to be what's best for the child. If the child's parent is not involved in the child's education, we want to make sure that there's someone there who is looking at that IEP and is there when they're developing that IEP. Okay, that was a very, very generic overview of IEPs. So please don't know that you don't have enough yet. If you have that issue, you want to talk with some educational attorneys or take a look at some of the other trainings. Okay, case plan compliance. The court is going to want to know where mom and dad are on the case plan compliance. However, the court should also be looking at whether the department is in compliance with the case plan. If mom is supposed to do substance abuse, let's say she's supposed to go to a substance abuse evaluation, if the department did not make the referral until the night before the judicial review, mom is not in non-compliance. The department is in non-compliance because they didn't do what they needed to do so that mom could make her case plan work. The consequences of the level of compliance. If the parents have failed to substantially comply with the case plan, that the court says, look, this is not going anywhere, reunification is not likely, the court could then say we're going to look towards other options, including a filing of a termination of parental rights. If the parents have substantially complied with the case plan, the court shall order reunification unless it is shown that reunification is detriment to the child. This is a huge issue because sometimes what will happen is a parent will comply with the case plan and your client does not want to go home. This is where you need to be able to argue that the child's safety, well-being, physical, mental, or emotional health will be damaged or harmed if reunification is forced on the child. Some of the things you can suggest is child is not ready, we need to have some family therapy, we need to amend the case plan so something happens so we can get the child in a position to go home. Anyone who forces, for example, a teenager to go to a placement that they do not want to go is asking for trouble. And a court will say, yep, we agree with that. We need to put some services in place before that happens. If the department has not complied with the case plan, the court can find them in contempt, can order a specific order that gives them a timeline to get those services in place, and also can threaten to remove or return the child over their objection because of their failure to comply with the case plan. If your client wants to go home, you can argue for this. If your client does not want to go home, you don't want to remind the parents' council that this provision exists, right? You just want to stand there, twiddle your thumbs, and wait until they go on to the next case. The court can also order concurrent planning, which means that the court is going to order perhaps reunification and adoption as the case plan goals. And that sounds somewhat counterintuitive, right? How can you be working to get the child home and also find the child a permanent family? Well, it actually happens all the time. What will happen is you have a young person that maybe is placed with a relative or non-relative or even a foster home who says, look, we are going to support mom and dad to get themselves together. We're going to help them. We're going to facilitate visits. We're going to drive them to their treatment programs if they need it. But if they don't get it together, this kid gets to stay here forever. So we'll be willing to adopt the child, but we will also help the parents to go home or to get their case plan task. And what that does is keep the child stable, because ultimately, if they're able to go home, those relatives will still be there to support the child. If the child is unable to go home, the child is already where they are. We don't need to start scrambling to come up with another alternative. Does that make sense? Okay. Okay. When should a case plan be amended? A case plan can be amended at any time. We want to do it if we need to change the goal. If reunification looks like it's not likely, we want to look at another goal to suggest that maybe we need another concurrent plan because we're not making enough progress fast enough, to add or remove tasks. If we've just discovered an issue, mom now is finally clean, and we've decided when she talks to her counselor, there are some serious anxiety issues. We needed to go into drug or mental health counseling. If we need some services added to the child's part of the case plan, or to update the child's medical records. Just a note there, when a child has a task in a case plan, you should advocate to cross out the word task and put services. Children get services, they are not tasks. The agency should provide those services to the child, and the child should receive those services. But children shouldn't have tasks in their case plan. They are the folks that we're supposed to be working with to provide them with services. The case plan can be amended in several ways. All the parties can get together and say, this is how we want to amend the case plan. We submit it to the court, and the court can sign off on that. If there's not an agreement, we can go to the court. The court can say, I don't like this, I'm going to change it. Or we can file a motion, say we want to change the case plan for the following reason, and here is our evidence in support of that. The court is going to take a look at that and make a decision. Any amendment must comply with the same requirements for the initial case plan. It's going to be the least restrictive, least intrusive, specific services to help the family remedy the services or remedy the issues that led the child into the dependency case system. The red note at the bottom is incredibly important. Sometimes when we've got these cases that go on forever and ever and ever, we've had multiple amendments to the case plan, and you've got a parent who is working off that original document, and if they're not stapling every time the court orders an amendment, they don't know what's accepted of them. So if there's a substantial change to the case plan, or there are new tasks or tasks are removed, as the child's attorney, you may want to suggest to the court, or argue to the court rather, that they issue an order requiring the department to submit a new updated case plan with all the tasks on there so everyone's on the same page and knows what's expected. I mean, one of my favorite things in the hearing is when the judge or general magistrate says, what are the parents' case plan tasks? And there's like silence. But it's the roadmap for the case, so we should be able to pull a document out that says, here are the tasks. And if we're not able to do that, it's probably time to get an amended case plan with all the updated tasks filed with the court. Okay. Youth ready for leaving foster care. The statute lists a requirement of documents that children should have when they are ready to leave court or ready to leave foster care at age 18. These documents are important because they're really hard to get on your own. And we want the agency to work with a young person to make sure that they've got their ID, their driver's license, if they're able to do that, a copy of their birth certificate, their social security card, information about the services they're entitled to, a bank account. One of the issues is whether they have the ability to open a bank account, and we'll see that there's an ability to ask the court to waive non-age or non-age so that the child is able to open a bank account, enter into a lease so they're ready to go when they're 18. The updated case plan must include the services that the young person is receiving. And the last thing is the most important thing, plan for normalcy. A young person has got to have something in their case plan that says this is how the young person gets to experience a normal life. It includes the ability to sleep over at a friend's house. A lot of young people will complain about the fact that their case manager will say, you're not allowed to go sleep over at Johnny's house unless Johnny's mom and dad come in for a background check. I can't imagine anything more mortifying than having a new friend ask me over for a party, and I say, I'd love to come. Can you give me the names and social security number of every adult in your house? I mean, who's going to invite me back, right? I'll be like, yeah, we're not having you. And so that's one of the things that a plan for normalcy allows is normal activities for a young person. The other thing is allowing kids to experience life in a traditional way that other teens experience. For example, one of the requirements sometimes is that a child has to turn in their receipts or an accounting of what they need money for. So, for example, a young woman wants to go to prom in June. She's required to turn her paperwork into the case manager in January, so there's time to process the paperwork. Who knew their prom date in January, right? I mean, doesn't that happen in May? Like you're all angling for whomever you want to go to prom. So teens in foster care get the right to normalcy as well. And so there should be part of their case plan that addresses that. If Jess wants to go to prom, she should let her case manager know what the fees are approximately. Case manager should submit a request for those services, but she doesn't have to do it 6 months out. That's not fair. That's not normal. That's not how our teens experience their lives. Make sense? Another great place to watch out for templated language. Again, my favorite way to check for that is if it has another child's name in the plan. That generally means that it has been cut and pasted from another child's file. And you think I'm being sarcastic. I am not. It happens all the time. Okay. You also want to look and see what the IL services are. These are just like reasonable efforts. If a young person takes an independent living assessment and the assessment says, Jess is good to go, the only thing she doesn't know how to do is budget, my independent living service plan should include the fact that I'm going to be taking budget classes, I'm going to get an allowance, I'm allowed to open a bank account, I must learn how to use my money, I've got a savings goal. It shouldn't say that I'm learning how to wash my clothes. Because last time I checked, learning how to do laundry had nothing to do with balancing my budget.
What if you have a child that has some mental issues and is not 17 or 18 mentally and cannot comply with this list? What do you do?
I think that's a great question. The question was, what do you do if you have a client who does not have the mental capacity of complying with all these requirements? The assessment of your client should be what services does your client need to be in a position that he's okay or she's okay. So if she is unable to budget money and will never be in a position to be able to budget money, then everyone needs to have a meeting. Well, who's going to help this young person manage their money? Do they need a rep payee if they're receiving benefits? Do they need a guardian if the disability is that severe that they're not going to be able to make any decisions? Or do they need a basic budget class and then the more advanced budget class? Or how do we work with that young individual? Independent living services are not, first of all, that's not how young people learn how to be independent. We don't go to classes. We learn how to be independent by watching responsible adults around us. That's how we all learned how to do it. When kids are in foster care, we set up these artificial things and we think that somehow they're going to get it. It doesn't really work that way. But what is really important is that we work with individualized plans for each specific child. And it may be in a case of a child who has some cognitive limitations that they're not going to be ready to live independently at 18. So we need to meet and have a plan in place about how that child is going to live, where they're going to live, who's going to help them. We should start to identify adults in their lives that are going to provide support immediately, not assume that we're going to just place this child in an apartment at 18 and wish for the best, because we know it's not going to work. Yeah, great question. Okay. Again, we've got our pieces about extending jurisdiction, and I think the most important thing that an attorney can do, if you will star what IL services is the youth eligible for post 18. Florida statute, remember we're going to look in the other section, is very specific. The length of time a child has stayed in care, the type of placement a child has been, the age that they were adopted, the age that they were placed in a permanent guardianship, all impacts their ability to receive independent living services. As soon as you get a case, you should know all those things. Where is your child currently placed? How long have they been there? Have they ever been in foster care? How long were they in foster care? How long were they in foster care post their 16th birthday? We need to know these very specific things. This is an assessment that is very important. So not that we have to do something about it unless our client wants us to, but rather it gives our client the opportunity to make an informed decision about what his or her options are. It is critical. No one wants to wait until the day before an 18-year-old's birthday and say, wait a second, we suddenly realized that because you were with a non-relative for the last year of foster care, even though you spent 16 years in foster care, and we moved you to a non-relative when you turned 17, that now you are eligible for nothing. And it happens all the time. We want to make sure that we advise our clients. If our client says, I don't care because I was going to die in foster care, I'm happy to go, that's fine. But what we want to do, just like we do with every other client, we want to advise them of what their choices are and the consequences of their choices. Did I scare everyone now? Yeah. Okay. Here are your prep tips. And let's talk about Brian. Concerns or issues about Brian? Anyone just want to cry for a few moments? Yeah. Go for it.
Your first concern, you make sure that you have a guardian ad litem because, I mean, he can, what if he tells me what he wants? And he has an IQ of 53, and my responsibility is to do what he wants, and I can explain it until I'm blue in the face that that's not the best thing for him. I mean, how do you deal with that? It puts the attorney in a, I think, untenable position. I mean,
Okay, so the question was, should I ask for a guardian ad litem because Brian has a low IQ of 53, and how do I advocate for him because I'm going to advocate for what he wants, and what happens if that's not appropriate? I think probably I would back you up one step. The first step is probably to talk to Brian and find out what he is arguing for, what he is asking, and then go through his options and see if he's making good decisions. Just like any other client under disability, we advocate in accordance with our client's ability to make the best decision that they can at that point. It's not an all or nothing. The fact that someone has a low IQ doesn't mean that they're not able to express a very meaningful position about what's going on in their life. Someone with a 53 IQ knows their life better than we probably do. If they are making a decision that is legally risky or physically dangerous, and you feel like there's a problem that you're not able to advocate that, then absolutely it's appropriate to think about asking for a guardian ad litem and seeking that. What you could do is you need to be careful about what guardian ad litem you are asking for. Are you asking for a guardian ad litem who's the child's attorney in a role of a guardian ad litem who is going to advocate for the child's legal interests or best interests? Or are you asking for a volunteer guardian ad litem? You need to think about who you're looking for and what you're looking for that person to do. Okay. Any other concerns?
My concern is that he's 17, he's been in the foster care system since he was 10, and it appears that nothing has been done for him as to his mental health services. I mean, he entered into DJJ, they're stating, I guess when he was in it for 18 months, he's now 17. Were those issues for his mental health ever addressed on the dependency side?
So there's some huge issue about whether the dependency case ever even addressed his mental health issues. And then it looks like he kind of hung out in a DJJ facility for 18 months, and we don't know what happened there either. So we don't know if he got anything while he was there. We certainly don't know what's going on with his education, do we? Other than the fact that he is well below grade level. Who are his resources?
His 20-year-old sister is very confused.
So he's got a young sister out there that we could potentially look at for a resource. Anyone else see anyone else that might be a resource?
The case manager. I mean, I'm going back to that because I'm thinking, why isn't it the case manager who would have seen this child, probably wanted to assist her, done something?
Okay. So we are worried about what the case manager has been doing in terms of finding services and meeting Brian's needs. What else could the case manager do? Who could the case manager potentially look for?
He's got older siblings besides his sister too, to see what their situation is, and he may be closest to his sister, but his sister's 20 and has 2 children, so there may be another.
So we want to look for other siblings. Okay, I'm going to pull this out of you.
To the parents, to the.
Wah! Yes. So the one thing is, can we also go back and look at the parents? The parents' rights have been terminated. When were they terminated? Okay, so 7 years ago, something was going on and the parents' rights were terminated. A lot can change in 7 years. So we might want to go back to them and say, wait a second, where are you? Are you resources? If not, do you know of other folks? Sometimes parents sign off parental rights, not because they're not willing to be resources, but they think that the child's going to be adopted and have something better. There may not have been massive issues that prevented the parents from parenting, but they may have done it because they thought something better was going to happen for their child, and then it didn't. So we want to go back and look and see if there are any options with the parents. What other issues?
He is enrolled in school, so there might be people there that are, that know what's going on a little bit.
Right, so we want to go to the school and say, well, what do you know? And then also, what plan do you have in place? Because if he's got special education services, he's entitled to receive those services up until he's 21. What's your plan for him, right?
Right, you should have an IEP.
Right, he should have an IEP. We also want to look and see if there are any other agencies that can step in and provide support for that child.
Are there, I'm sure that there's additional services for extra tutoring since he is a special needs child to enhance his educational integration goals?
Yeah, absolutely. The question was, would he be entitled to any additional education services like tutoring? And the answer is sure. The question is, where would we get that from? It may be required as part of his IEP. It could be that he's receiving some disability check, that we could use some of that money to pay for tuition assistance or tutoring assistance. And it could be that we want to go back to the case manager and say, we need to get some serious services in place to bring this young man up to speed, which kind of goes back to your story about if you've got a child that has cognitive difficulties, what do we look for? We look for whatever this child needs, and we look for whatever avenue we can find to meet those needs.
Agency for Persons with Disabilities.
Thank you, APD.
I mean, his IQ is going to stay static for his life, so he needs to be planned for in a way that it's a long-term condition and some alternative decision maker, if one's necessary, needs to be considered for the long haul. Like you said, it could be the parents, it could be family, could be potential for a guardian advocate because they don't necessarily need to get a full-blown legal guardian, but he needs to be set up for his future. And that Agency for Persons with Disabilities has a waiting list of thousands, but there's a way to get prices to funding and
Particularly since it looks like this young man might be homeless, would be a way to get him off the APD wait list.
and then they have wonderful services once you can get adequately funded for them. So.
Absolutely. So there's a lot of things we can do. The other thing, too, I want to make sure, since we have a case manager that perhaps hasn't done all he or she could have done, I want to make sure that they've applied for disability benefits for this young man, because if they haven't, we want to get on that right away and not wait until he's 18. We want to get that process going and see if we can get some either funding in place, because if he is eligible for SSI benefits, then he's also entitled to medical assistance, which is going to be a huge benefit later on in his life. Okay. All right, here are what the court could and should order. Remember, we're going to be looking for amendments to the case plan, looking to extend jurisdiction, seeing whether reunification is appropriate or another case plan, and we're going to look for protective orders, and going after contempt proceedings if the agency hasn't done what they should have done, particularly in regards to our teenage clients. Here are your next tip sheet, and let's go on to permanency hearings. Okay, permanency hearings. This is what the goal of dependency cases are. We're looking for what this child's long-term goal is, where their forever home is going to be. The first permanency hearing has to take place 12 months after the child was removed, or 30 days after the court says we're not working on getting this child home, and then we have to have one every year thereafter. And the idea behind these hearings is we're going to look to see when the child is going to achieve that permanency goal, whether we need to change it to something else, and whether the current goal is in the child's best interest. The court, welcome to Alice in Wonderland, can consider anything and everything that makes sense in making their decision. Okay. What should the plan be? Should there be a concurrent plan? Has the department made efforts to achieve that plan? And when a plan is achieved, what can happen to make that plan change? Okay, here are our permanency plans. Reunification, that means go home. Adoption, that means get a new family and go home with them. Permanent guardianship, it means get a sort of new family and go home with them. Permanent placement with a fit and willing relative means stay with a relative, but stay involved in the dependency system until you're 18. Placement in another planned permanent living arrangement, APLA, just means something else, and we'll get to it. When a court determines what plan is appropriate, here are the 3 statutory considerations. What plan is in the child's best interest? That's a big one, right? Does this make sense? Is this good for this child? What does the child want? Yay! First time, like the child's preference is really highlighted in the statute. And third, what does the guardian ad litem recommend? Interesting that those are the 3 choices, but that's what the court is going to look at when it's making its determination. We also want to think about should there be a concurrent goal, and I think it's important just to remember where your client is placed. If they're with the relative or with the siblings' relatives, we may not have to go after adoption or TPR if necessary. It's just important to know that. Okay, so let's talk about permanent guardianship. Permanent guardianship can be granted to a relative or a non-relative, provided that the child has been in that placement for 6 months, at least 6 months. The person that's taking guardianship has to be suitable and able to provide a safe and stable home. They are supposed to not likely be in need of additional services, and they've got to commit to caring for the child until they're 18. They're supposed to notify the court if they're going to change their address, and under no circumstances are they allowed to give the child away. So grandma can't take permanent guardianship only to leave the courthouse and hand the baby back to mom, or to put the baby up for adoption. Bad, right? Grandma is committing to keep that child until the child is 18. The court's got to say we're ruling out reunification. They've got to say why they think permanent guardianship is better than adoption. The court order should address visitation with the parents or any siblings that aren't in that home, and must include that language, don't give the baby away. Okay? Permanent guardianship is not like guardianships under the 700s, 744. Jurisdiction is maintained, so if there is an issue, we can all come running back to court. The department closes its case. It is no longer sending a case manager out to the home to check on the home. The case is closed. And the last thing is really important. Guardians should get a separate order that establishes them as the guardians. The reason for that is our orders are juicy. They have all sorts of wonderful facts in there. You know, mom was strung out on drugs again. We think that she's prostituting. Dad is up the river for selling drugs. The brother's in jail. We think sister's a mess. We've got all these wonderful facts in the court order. So good meeting guardian goes off to the school to say, I'm the guardian, and hands in that order. Now the school has got all this background information on the family that probably our client doesn't want anyone to school to know, particularly when the school secretary takes it and flips through it and then maybe hands it to the next person who puts it in the file, particularly when there are sometimes student workers in offices. So what we should do is request a separate order that says this child is placed in the legal custody of Mrs. X. That's it. That's all it needs to say. The court can sign it, date it. It's a separate order that the guardian can use when receiving services. Great way to preserve our client's confidentiality. Okay. Placement, permanent placement with a fit and willing relative. Folks who practice in Hillsborough County, show of hands, who sees this happen? This permanency plan of placement with a fit and willing relative? Yeah, and that's, no one's raising their hands, and that's my experience as well around the state, is that this is a permanency plan that folks generally aren't using. What it is a relative steps forward and says, okay, the child is placed with me. I'm going to keep the child until the child is 18, but I don't want to take permanent guardianship, so the child is just going to stay with me. I'm going to commit to care to the child until the child is 18. But nothing changes. We still keep coming back to court every 6 months for a 6-month review. The court jurisdiction is still open. The agency still sends a worker out. This case is still absolutely open. The reason why we might use this plan is maybe the relative is not ready to take permanent guardianship, or we're trying to figure out if the child needs any more services before they get to the point. But this is still very much, the child is hooked into the dependency system and they haven't stepped away from it. I really have never seen this happen. So, and it seems like in Hillsborough it's not an option, or it's not used very often. I'm not saying it can't be used, it just seems a little odd. Again, because we're still coming back to court every 6 months, parents can come in and say, let's change it, let's change the plan. Okay, APLA. When can APLA be granted? Okay, first of all, everyone grab your pen. Cross out APLA. Cross it out. In its place, I want you to write something else. Write the words, something else. Everyone looks at me like, what? What else do you want me to write? Write something else. Okay, and this is why. APLA stands for Another Planned Permanent Living Arrangement. So, but this is how it happens in factuality. We go to court. The judge says, Miss Ray, what is Johnny's permanency plan? Well, Your Honor, Johnny's plan is APLA. And everyone's like, yes, APLA, right? Okay, it doesn't work like that. We haven't come up with anything yet. If I go in court and the judge says, Miss Ray, what is Johnny's permanency plan? And I say, well, Your Honor, Johnny's permanency plan is something else. The court is going to say, well, what is it? And then I have to be able to explain what that permanency plan is. An APLA plan must be child-specific. It's got to be designed to make sure that the child is okay. It has to be you have to consider all the factors in the child's life. It has to be something more than just the acronym. Okay? When APLA can be ordered, it has to be when the other plans are not an option for the child, that the department has documented reasons why the placement will endure, why it will last, and why the proposed plan is more stable than ordinary just hanging out in foster care, and the court finds that the child's health, safety, and well-being is not jeopardized by that plan. Compelling reasons for an APLA plan include, but these are not criteria. The kid doesn't have to meet every single one of these. These are examples of what the court might consider. That the children have a bond with their parent, but their parent is not in a position to care for them. That the child has, I just blanked out for a second. That the child is a member of an Indian, under the Indian Child Welfare Act, is a member of a Native American tribe, or the child is 16 years and older, wants to remain in his current foster home, and the foster parent says, look, Johnny gets to stay here. He's going to stay here until he's 18. In fact, he's going to stay after 18. His permanent placement is, the bedroom on the top of the stairs. When he goes to college, I'm going to be driving him to college. When Thanksgiving comes around, he's going to be coming back to me. When he gets married, I'm walking them down the aisle. He's my kid, but I'm not in a position to take permanent guardianship. He doesn't want to be adopted, so I'm going to be his mom, but I'm going to stay his foster parent. That's what an APLA plan is. It's specific. It's considered, it's designed to make sure that our kid is okay. Okay? That being said, there is a lot of pushback about APLA. APLA is bad for statistics. Agencies get dinged for this. This is something that there's a lot of, we don't want to do APLA, that's long-term foster care. It's not. It shouldn't be long-term foster care. APLA is a way to find permanency for kids in a different way. What happens is there's a lot of pushback about, well, this is not really permanency. Why would you deprive a child of a permanent family? And what I think is very important as a child's attorney to do is remember that what we want is actual permanency for our clients, not paper permanency for everyone else. Okay. I'll give you an example. Our client is in a foster home with a foster parent who she really loves. That's where she's going to be until she's 18. That's where she wants to stay. There's a lot of pressure on the foster parent either to adopt or to move the child to a relative who will take permanent guardianship. Why is that? Well, first of all, if we can say that an older child in foster care has been adopted, we can all hear those heart stories. We all feel good about ourselves. We all did a good job. Yay, us. If the child is in permanent guardianship, again, we all feel good about ourselves. We found a permanent family for a child. It makes us feel good. It makes the adults in the system feel good. It's even better because as an attorney, once my client is adopted or placed in permanent guardianship, I get to close that file. My caseload goes down one, right? Same thing for the case manager. They get to close their file. They go down one case. Same thing for the court system. That case goes away and the court system gets to close that file and move on to another case. But what it doesn't do is consider whether that permanency plan was best for that child. If that child remains in foster care and what's best for them is they stay there because there is where they get to remain in their high school, they get to continue to do their activities, they get to see their boyfriend or girlfriend, they get to see family friends, they get to finish their high school career, they get to go on to college, they're eligible for independent living services. That's permanency for them. The fact that we're all bothered about the fact we have to come back to court every 6 months shouldn't matter. Permanency plans should be based on what is best for the child, not what is best for the adults in the system. And so, even though APLA is disfavored, do not buy into the fact that APLA isn't appropriate if that's what's best for your client and that's what your client is asking for. It is not something that we should waive simply because we're caught up in that fervor. Whatever is appropriate for our client is what we should be advocating for, right? Appropriate meaning that's their position, right? Okay, reasonable efforts. The court needs to document that the agency has made reasonable efforts to finalize the plan. They have to be specific again to that case. The court order should state what efforts they found that the department has done, and they should actually mean something. So if reunification is the permanency plan and the parents are dead, we got a problem, right? Right? Because you can't really reunify with dead people. Okay. Well, you could, but that would be under a whole different system. No, just joking. Okay. Are there any services that are currently in place? Are there any other services that we need to order? Are there any barriers that are preventing finalization of the plan? Is there something that the agency could be doing to overcome those? For example, if the mother is ordered to participate in visitation and she's saying, I can't get to the visitation center because it takes me 4 buses, then we need to think about something different. Maybe visitation doesn't happen at the agency office. Maybe the child is driven somewhere halfway, so mom only has to take 1 bus or 2 buses. We need to think about ways to ensure that we are promoting permanency and making sure that that plan can be met. Sometimes I think we get so, as Robin said, we can kind of get stuck in our place. Well, we never do it this way. We only do it this way. I think it's encouraging to say, a new attorney comes in and says, well, that doesn't make any sense. If it doesn't make sense to you, it probably doesn't make sense in the plan. Challenge it and ask for something different. Folks with me? Okay, modification of permanent placement. When the court orders a permanent placement, it is the intention that that is going to last until the child is 18. The court is not going to disturb that unless it's in the child's best interest to do so. If a parent is coming in to undo a permanent guardianship, let me back up. An adoption cannot be undone. Once an adoption is done, as long as there's no irregularities within that first year, once the adoption goes through and a year has passed, it is done. You can't come back and undo it, right? A parent can't say, all right, I got myself together, unadopt the child. Permanent guardianship, a parent can come back in and say, look, I have done everything I was supposed to do. I've now done it. I want my child back. The court should not consider that request until the court decides that it's in the child's best interest to consider the request and open the case. The court is going to look at the parent's compliance, the circumstances of dependency, how long the child has been in their current placement, where the child wants to be, what the caregiver wants to have happen, and if there's a guardian ad litem, what their recommendation is. The idea that the parents have to show it's in the child's best interest to disturb the placement is a way to try and prevent parents using this as a way to drag the caregivers and the child back to court, just as a way to harass them. Let me tell you, it still happens. There are still these cases where folks will go back to court time and time again as a way just sort of to aggravate the caregivers. As the child's attorney, if you're involved in the case, you can ask the court to stop that or to hold an initial hearing to determine whether it's in the child's best interest, even to have a hearing to disrupt the permanent placement, and that way protect your client from feeling that if that's what your client would like you to do. Okay, local practices. If folks are calling Apple long-term foster care, please yell at them, say Jessica. They'll ask who Jessica is, just ignore them, say Jessica says no. APLA is not long-term foster care. It's something else. It's got to be a plan, specific plan. Okay, here are your preparation tips. Let's talk about Abby. Abby is right around that 12-month mark in her case. She's been in care about a year, and we have to figure out what we're going to do for her in long term. Any issues? Concerns?
It says that her father died in Iraq, so maybe we're looking into whether or not he was military and she might have death benefits.
Great. Dad died in Iraq. Maybe he's military. Maybe there are death benefits. Dad died in Iraq. Maybe he's Iraqi and she's not an American citizen and we've got some immigration issues. Yep. What else?
What does Abby want?
What does Abby want, right? Abby is 11. She's very intelligent. I'm sure she's got some feelings about where she wants to live. What's happened to Abby since she's been in care? I missed something back there.
She's doing very well.
She's doing really well. She came into care and now she seems to have settled down and is beginning to do really well in school. Has she had school stability in her life? No. We know that she changed a bunch of times with mom and then she changed a couple times until she got with grandma, right? Any concerns about grandma?
Grandma doesn't like mom.
Yeah, grandma's not a big fan of mom. Where does grandma come from? Yeah, so we don't know whether grandma's in Florida or grandma's just in Florida for the snowbird season, or if she intends to stay in Florida, or if she's planning on going back north and is going to be a long-term resource for Abby, right? She could just say, look, I came down to step in for a little while, but, you know, whenever folks go back north, she's going to go back north, and she maybe doesn't want Abby to go with her, or maybe she does, right? And that's going to have a huge impact on Abby's ability to have contact with mom, right? Any other concerns or issues? That she'll have to go to a new school if she goes back to mom, or if her placement changes again?
More importantly, mom was reunification, but what's mom's mental health status? Did she get solved? Are there ongoing issues?
Okay, so mom wants reunification, but we don't know whether she's in a position to be reunified because we don't know what the status of her mental health issues are.
I thought the amount of overnights was low.
So we wonder if mom has been having enough overnights with Abby to see where they really are, right, in their process of kind of getting reconnected. Any other issues? Yeah, I mean, I think you guys did great on that one. I think the big issue is, what does Abby want, and when does she want it? Because if Abby is towards the end of the school year, it may be that Abby says, look, let me stay with grandma until I finish the school year, and then I can start a new school year with mom, or I can transition over the summer, or I can transition over the winter break. We need to know where we are in the school year, because that may have a huge impact on what Abby wants, right? Or Abby can say, get me the heck out of Dodge, I want to go home to mom tomorrow, right? And we can talk to her about what the consequences of that are, including if she's trying to earn credits or something, that she might lose some credits, and we can advise her on what those options are, right? Abby's our client. She directs our representation, so we just need to talk with her about what's going on and what she would like to see happen, right? Just a quick note for Abby's case. Just because we have to wait, we have our permanency hearing every 12 months, doesn't mean that we have to wait until 12 months have passed in order to be reunified. Kids can go home well in advance of the 12-month hearing. We don't have to wait that long. It's not, if the family is ready or the case is ready for whatever the permanency plan is, doesn't mean we have to wait until the next scheduled hearing. If we need to come back for a court order, we can do that. But if the agency says, look, mom is ready to go, we're ready to go for reunification, they can go to court and file a motion and say, look, our permanency plan is not until, or our permanency hearing is not until December, but Abby's ready to go, we're going to look for something else now. There's nothing to prevent that. We are not stuck in the regimented hearings. Make sense? Okay. All right, here are what the court could and should order. This is a great time to look at asking for a concurrent plan. If we are still working towards reunification, but there's something in the case that makes you think, yeah, this is not happening, we want to start looking to see what other options we might have, including permanent guardianship, or if the young person wants to be adopted or is really little, start looking for adoptive resources. There is no reason why little ones who maybe are, or little ones, any little ones, are placed in a foster home or a relative home or a non-relative home who's not adoptive and whose parents are not working towards reunification. We shouldn't house kids for a year while we get our act together. We should start immediately looking for a family that says, look, we'll work towards reunification, but if it doesn't happen, we're a permanent placement for the child. There's nothing worse, I think, about having a child. My favorite factual situations are when a little tiny one is placed with a couple who is 76 and the child is 2. And the child is there for 2 years. And when the child has then been there for 2 years, the couple is now 78. And we say, oh, we've got to find a family. And then everyone says, well, but we don't want to let them adopt because they're too old. Well, what did we think would happen? Did we think they were going to get younger every year? Did we think the child wasn't going to bond? We need to make sure that when kids are placed, that we are thinking long term. If whatever the goal is not going to work out, is this some place that the child can stay? And are there any barriers or any concerns that we need to address now?
I have a question. What happens when permanent guardians die?
That's a great question. When permanent guardians die, usually what will happen, because the court has maintained jurisdiction, that case will come back into court, and then we will open it again and look for other resources. In an ideal world, what would happen is the permanent guardian would say, if something happens to me, here's who I designate, and that person will contact the court and say, so-and-so died, she designated me, I'm ready to go, I've had a relationship with the child, and so that's put in place. When someone adopts, if the adoptive parent died, they do designate a standby guardian. Thank you, I couldn't think of the word. They do designate a standby guardian so that there is something in place, and those don't come back to court because it's just like in a non-dependency case that someone would step up for guardianship. Unless there wasn't there, then it would come back into court. So that's what happens.
You just gave a really obvious example with 76-year-olds and 2-year-olds, but is there a standard, is 62 too old?
No, I think it really specifically depends on the age of the child and the age of the caregivers, and what makes sense. I think there's a difference between a young person being placed with their elderly grandmother and having a whole slew of relatives in the works that say, well, if grandma dies, you just come and live with aunt because you're still part of the family network, or a baby with someone who's older, or a 17-year-old with someone who's older. I think it makes sense. It's got to be fact-specific and case-specific with all those considerations. I mean, we never know who's going to be taken out by a meteor, right? So we can't, say that this person's going to be there forever. But there are certain factors that just make sense. If you place a baby with an elderly couple, they're only going to get older. And at some point, someone's going to raise the concern that perhaps an 80-year-old couple shouldn't adopt a 2-year-old baby because they will have to be 96 and active when this child is 18, and you heard my big spiel about no one's ready to be alone when they're 18. So unless there's a lot of resources that family has, including, younger children or aunts and uncles who are going to step up, that's probably not the best resource. The other issue, I think, is sometimes the harder one, is where there is a young relative who steps forward who says, I will care for my niece. And the child comes and stays with their aunt, and the aunt the whole time says, I'm not going to adopt this baby. And the child lives with their aunt for 3 or 4 years and now is 5 years old. And the aunt says, I told you I wasn't going to adopt. And now the agency says, well, now we're going to start to look for an adoptive resource. The big question is, you're stuck in the middle of, well, will the aunt take permanent guardianship? Do we need to hunt for an adoptive resource? Is the aunt willing to take permanent guardianship? What does the child want? What's the aunt willing to do? And that may be where we start arguing for maybe the fit and willing relative piece, because if our client wants to be there and the aunt wants to keep her, that might be something that we argue, and the agency is going to say we're really uncomfortable because this 5-year-old deserves a permanent family. That's where we go back to what's permanent for the child versus what's permanent for the adults, right? Yeah. They're not easy cases. They can be very heartbreaking, because you can see them happening, and we see it all the time. Okay. Any other questions? Okay, here are your next steps. And now we're on the big dog, TPR. Okay, we're going to go through when a petition must be filed, who can file them, and what the process is. Okay, when must a termination of parental rights petition must be filed? The department is required to file one in 60 days if the child has not been returned to the physical custody of the parents at the first 12-month review. Okay, that rarely happens, but that's the first standard. Okay, second, the child has been in state-supervised care for 12 of the most recent 22 months. A parent has been convicted of certain crimes, or the court determines that reasonable efforts to reunify the child with the family are not required. And then, of course, in law, we always say unless or except. And that is, if a child is placed with a relative, the agency doesn't have to do that, or if the department has documented compelling reasons why they shouldn't meet that requirement, which sort of negates everything that just came before us. But here are some of the compelling reasons. One is adoption is not appropriate. This is an issue for like our older teens that want mom and dad to still be mom and dad, but they don't want to be adopted. There are no grounds for TPR. The child is an unaccompanied refugee minor. Never seen that. There are international legal obligations or foreign policy reasons. I so want to have that case. I don't know what that is, but I want that case. Or the department has failed to provide reasonable efforts or services to the family. Okay, I love that because I want to see that documented somewhere. Your Honor, we can't file for TPR because we didn't do our job. Like, I would love to see that written somewhere down, but yeah. Okay. Upon good cause shown or on its own motion, the court can review the department's documentation of compelling reasons for not filing. So if the department's saying we're not filing and you want them to file, you can file a motion and ask the court to have the department come up and prove what their compelling reasons are. Tell the court why they're not proceeding towards TPR. Okay, when can a TPR petition be filed? Any time that you have legal grounds to file. You do not have to wait till that 12-month mark. You do not have to wait until the 6-month mark. You can file a TPR petition at any time, provided that you are doing it in good faith and you have grounds for the TPR. Who can file the petition? Anyone, including the child's attorney. So if that's what your client wants, you have the right to file that petition. Here are the technical requirements for a petition. You've got to allege the ground, that the parents had the right to counsel, that the child was previously adjudicated dependent. That's where you're really wishing you'd listened to me when I told you to check your old files to make sure if there was a withhold of adjudication, the court went back and fixed it, right? That TPR is in the child's manifest best interest, okay? Got to provide notice to the parents, the legal custodians, the people that actually have physical custody of the child, a grandparent who is entitled to priority for adoption. That is usually a grandparent who had had custody of the child for at least 6 months in the last 2 years. If there's a guardian ad litem on the case, you've got to notice them. Okay, who's missing? Like, who are we not notifying that there's a TPR petition filed? Yeah, we're going to take away your parents' rights. Right? No one knows about that, right? Okay. Civil rules of procedure govern the process and notice. And notice can be waived if a parent signs properly executed surrender. Okay, TPR advisory hearing. Hold on, let me just flip through my page and catch up with myself. Okay, this is held as soon as possible after the TPR petition has been served, but no less than 72 hours. You got to give people 3 days to get to court. The purpose is to let parents know that they have a right to counsel, to see if there are any pleas. If there isn't a guardian ad litem or the child is not represented by an attorney, the court has to do that because one of the factors is what the child's guardian ad litem or their legal representative recommend. If the parent does not show up for the advisory hearing, just like the dependency arraignment, the parent's consent can be deemed. Huge problem if you've got parents that are doing nothing, but your client does not want to be TPR'd, right? Because now the parents have now are deemed to consent, and your client does not want TPR to happen. So this is a great time to file a notice of objection, to say, Your Honor, you can deem a consent, but I'm asking you not to. My clients do not consent to a TPR. They do not want to be TPR'd, asking the court to set it for a trial, object early, object often, be obnoxious, make sure the court understands that your client does not want this to happen. Okay, the court is also going to schedule your typical pretrial conference. We're going to talk about witnesses, evidence, order of evidence, anything that's going on about setting up that trial. Okay, adjudication. This is the hearing. This is the big trial often in dependency cases. But I just want to say, in every single hearing, whether it's the shelter, the arraignment, the adjudication, disposition, judicial review, or permanency hearings, those are all incredibly important to your client. If they are needing services, if they're unhappy in their placement, if they're missing visits with someone, just because this is the big scary one, every single hearing is incredibly important to the child because they're the one that are living that life, right? Okay. So if it's a contested trial, we're going to have it within 45 days of that advisory hearing, unless we all get together and agree to another date. Most of the time, the attorneys are all going to get together and agree to another date because people aren't available. But remember, time is the right of the right. So you don't want to be pushing it out or setting it way out if this is what your client wants. If your client is objecting to TPR, I'm thinking December 2017 is looking really free, right? Push it out, push it out, push it out, right? So whatever is consistent with your client's position, set that date accordingly. If it is voluntary, if the parents have consented, then you're going to set it within 21 days of the filing of the petition. The purpose of the hearing is to try the facts, whether there are grounds for a TPR. The burden is clear and convincing evidence, unless ICWA applies. If ICWA applies, it's beyond a reasonable doubt. Rules of evidence apply. Okay. Basic considerations. I want everyone to grab their pen again. I'm going to make you write a mathematical equation. Everyone can now freak out. Okay. If a train leaves the station at... No, sorry. Okay. In the first brackets, I want you to do a set of brackets, and I want you to put CC. Okay. In the next, I want you to put an open bracket. I want you to put G plus MBI plus LR, close bracket, equal sign. Okay, so we've got CC times G plus MBI plus LR equals. Okay, what that stands for, in order to get TPR, you need clear and convincing evidence of the following: that there are grounds for TPR, that it's in the child's manifest best interest, and it is the least restrictive means. So your equals TPR. Okay, so let's go through grounds. Here are your grounds for termination of parental rights. They are statutorily based. You have to have at least one of them in order to meet TPR. The ones that are underlined are the grounds that can be used for an expedited TPR, which means that you don't have to make reasonable efforts to reunify with the child first with the parent. Let me make sure that I make this very clear. If you are seeking an expedited TPR, before you assume that simply because you've got one of these underlying factors that you are good to go, need you to go and do some very intensive research on the case law. even though the statute is clear that these are the grounds for expedited TPR, case law suggests that you probably need something more, such as harm to the child or a tie-in that makes it that expedited TPR is best for the child. Simply because you have one of these grounds is not going to be enough in most cases for expedited TPR, particularly involuntary TPR of another child, or a child or the sibling's been in and out of care 3 or more times. Those are the two that I think you're going to need a lot more than just those 2 grounds. Does that make sense to folks? So we've got it in the statute, but just be very wary. Egregious is really hard to meet. Okay, manifest best interest. The court is going to go through these factors and determine if, even if you've got grounds, is it in the manifest best interest to terminate the child's parental rights or the parent's parental rights. They're going to look to see if there was anything else we could have done. Was there a relative who could have stepped forward and taken something short of TPR or short of adoption? Are the parents able to meet the child's needs in any way, shape, or form? Is the child at risk of emotional harm if those ties are cut? If we do TPR the child, is there something going on with the child that we're going to TPR them for nothing because they're not going to be able to be adopted? Is the child attached to anyone? Is the TPR going to impact that attachment? Do we want to keep the child where they are? Are they already in adoptive placement? What is the relationship between the child and whomever they're currently staying with? Is that going to be their adoptive resources? What does the child want? Are they old enough to express a position? What is the guardian ad litem recommending? Or what is the child's legal representative recommending? So if you are the child's attorney, this is a great place to say, we do not recommend TPR in the child's best interest for the following reasons if your client does not want to be adopted. Okay. One of the best things is if your client is 12 or older, you can say, not only do we not recommend it, my client is indicating that they will never consent, so you are legally orphaning him or her for no reason. Okay. Very hard to get a TPR if that's the facts. However, the last thing is not a factor. It's something I want everyone to star, highlight, underline, make sure that they remember. Manifest best interest is not a comparison between the potential adoptive parents and the biological family. It is never who is better, right? Because if we were saying, who are the better parents, none of us would have been raised by our parents, right? There's always someone who could have done a better job. Better cookies, better bedtime stories, better homework assistance. This is never a comparison. It's not about whether, the foster parent is an A parent and the bio parents are a D parents. It's really about, are the parents passing or failing? If they're passing, probably don't have grounds for TPR. If they're failing, you may have grounds for TPR. It is never a comparison. So one of my favorite things is if there's a witness on the stand and they say, foster parents are just so much nicer, or their house is so much cleaner. Yeah, ixnay on that. That doesn't work. That's not grounds. And in fact, would actually probably be a great argument against granting TPR, that's why they're suggesting TPR, is because the foster parents are wealthier, have more resources or something like that. It's not a comparison, never a comparison. The court shouldn't be doing that. And if witnesses are doing that and you're opposed to TPR, I would jump all over that. Okay, so there are your basic considerations: grounds, manifest best interest, least restrictive, and clear and convincing evidence unless you have a child who is under ICWA. If yes, the court is going to write an order that includes all those facts and the conclusions of law. The court can order that the child be placed in the permanent custody of the department for the purposes of adoption. The court can occasionally do a one-parent TPR, but there has to be clear evidence about why that's in the child's best interest. You will sometimes see that if there's sexual abuse, and they're still working on getting the child back to the other parent if the parents were separate, a non-custodial parent. Very odd, because then what you have is a child who no longer has one parent, but they're not freed for adoption. So it's an odd place to be, but it does happen. The bottom sentence, everyone star, if it's in the child's best interest, the court can order post-TPR contact with relatives, and that includes the bio parents. Why would you do that? Why would you do that? that can sometimes be very clearly in the best interest of the child. If the child is going to go, grandma's going to adopt. You don't want grandma to say, well, at family reunions, mom or dad can't be there. It may be important to the child's well-being. If the child is 17, saying, look, I really want to be adopted, but I want to be able to see my mom if I want to. I'm worried about her. I want to be able to check in on her. It's incredibly important for siblings to be able to make sure that they maintain contact with their siblings if they're not in the same home or not a same adoptive home. So, huge right that belongs to the child. Okay. If TPR is not granted, it doesn't mean that the child goes home. Okay? The only time that will happen is if the whole case started with a TPR petition. If someone goes to court, files a TPR petition, and the court says, nope, no grounds for TPR and no grounds for dependency, the child goes home. Okay. If the child was already found dependent, which most of your cases, I would say all of your cases are going to be that situation, then the court will say, are the grounds for dependency still there? The court can either adjudicate or re-adjudicate the child dependent and return them to whatever setting they were. So if they were with a relative, they stay with that relative. If they were in foster care, they stay with that foster care parent. If they're a non-relative, they stay with that non-relative. So if you lose that TPR, it doesn't mean suddenly the dependency case is over and the child goes home to the parents. Okay. Does that make sense? Yeah, folks sometimes are really nervous if they don't win a TPR that somehow the dependency case goes away. It doesn't. Okay? You can file for TPR. You can try again, but you're going to file it under different factors, different grounds, different circumstances. You can't just keep badgering the parents until they submit, right? That tricky constitution. Okay, here are your preparation tips for the TPR. Some more. I just wanted to highlight this. When you prepare for a termination of parental rights trial, prepare the case as if you were the petitioner, as if you were the moving party. The reason for that is sometimes the case does not go as well as the petitioner expects, and if you're not there and not able to present the case in a way that actually supports the grounds and proves the evidence, that TPR petition will be denied. So prepare the case like it is your burden that you're going to prove the case on behalf of your client, because the agency is usually the petitioner, but if they don't get their evidence, or if their client, their case manager, or not their client, their witness, the case manager doesn't testify adequately, you want to have enough evidence, if your client is in support of termination of parental rights, to save that case. Good tip, just prepare it like it's your own case. Okay, let's talk about Cassian. Every time I do this training, I say I can't pronounce his name, and I'm going to change his name, and I never do. But okay, let's talk about Cassian. He is sort of at the TPR-ish stage. Folks got concerns, issues, anything that comes up with him. Say that one more time. Where are the other family members? That's right.
Well, it seems like he's really young, and the family is. What is the parents' issue? Is it just drugs? So is it too young? You know, is he too young to say whether or not his parents' rights should be terminated? That's what he wants, because in 5 years this could change. So it seems like a really hard age to make that determination.
Right. He's very, very young, and we don't know whether he's able to come to court and enunciate or meet with us and tell us what his preferences are. Yeah. I mean, I'd love to see the 3-year-old that comes and says, hi, I would like my parents' rights terminated because I want permanency in my life. I'd love to see that. It probably doesn't happen. But folks, does anyone have kids in the room? Anyone know kids? Anyone seen children? Okay. Yeah. Okay. Most little ones can tell us what they want, right? They're pretty clear about what their preferences are, right? Sometimes they say it in words, and sometimes they do it in actions, right? A little one is very clear about who they love or who they like to be around. And so as attorneys, what we need to do is think about how we get that information from this little guy. We might have to go over to the home a couple times. We might want to see him interact with the relative or the caregiver. We may want to see him during visits with the relatives. to see how he interacts, to see what options we have and what he's telling us. The fact pattern tells us that he's pretty precocious, right? And he's pretty verbal. So we could talk to him a little bit about that. But we might want to see what nonverbal clues he's giving us as well.
I don't know, it doesn't say what the situation of the visits were, but I know some supervised visitation facilities, I know down here at Children's Justice Center, they videotape.
Right.
Those if it were in a CJC sort of facility, those reports, the issue reports, those should be part of the record.
Right, so look at visitation records, see if you can observe any videotapes, or maybe watch through the glass if they're at a visitation center so you can get your own take on what's going on. Is there anything that we talked about? Sorry.
Who's making the petition? Is it the department or is it the foster family?
Right, that's a great question, and the fact pattern doesn't tell us. Who's making the petition? Who's filing for adoption? Is it the department saying we think that this is in the child's best interest, or is it the foster family saying we're ready to go because we want to adopt this child, right? And does that make a difference? Maybe, because there may be different motives involved, right? Okay. What else? What else?
It says he has 2 older half-brothers who he sees occasionally. Maybe what are their living circumstances? What relatives are they with? Is that a resource for him?
Right. So where are his siblings? Why isn't he with them? Why is he only having limited contact? And what tool did we learn about that you guys all put stars next to that we could use? Right? The post-TPR contact, if we think that adoption would be really good for him, but we could also say, but we think it's also really important. If the relatives say, well, you're not going to take him, but we really don't want to lose out on him, we can say, well, what about, continuing visits with all the family members and getting him permanency at the same time, right? Because remember, Cassian's legal rights are the right to time and the right to permanency. So we don't want to waive that without very careful consideration. It would be very difficult, I think, to recommend for a 3-year-old that we just hang out for the next 5 years and see what happens, right? That'd be really bad, because then what happens is we say, oh, well, you can't adopt him, we're going to find someone new, and cause all sorts of, baby being pulled from the arms drama. We don't want to do that, right? Right. Any other issues? Everyone comfortable that you can legally represent a little one? Yeah, little kids can tell us a lot about their lives, verbally or by watching how they interact with the folks that are important to them. Yes?
But, recognizing that he's very verbal and they can tell you what they want, okay? What do you do though when it's a parent situation where it's a case of neglect, it's something that they could remediate in 4 or 5 years, and now their parental rights have been terminated, and maybe that the child really does have a bond with their parents, and they're 8 and the parents now are having issues. How do you balance those considerations in your students?
I think that's a great question. And some of the things that I would do when I've had little tiny clients and I'm trying to make a decision about what's in their legal best interest, what's their legal interest, and what position I should be taking, is I talk to experts. I talk to folks that say, look, if a young person remains involved in the dependency system, there is research that shows that that's really bad. It's unstable. They tend to do less well. The parents don't tend to suddenly see the light. If they haven't done X, Y, and Z in a certain amount of time, it's likely that they're not going to. You can talk to the parents' service providers and see what they're doing. Are they making progress? Are they just a little bit slower? Or are they there just killing time? Or are they really not showing any commitment to stepping forward? If a parent is really trying, but perhaps maybe has had some good reasons for why they haven't been further along in their case plan, you might say, look, TPR might be an option, but we need to give them a little bit more time. And that could be 3 months, or that could be 6 months. If the department hasn't done what they need to do in order to facilitate or remove those barriers, you say, we need 6 months, and you guys need to do this so the parents can do that. And then at the end of that, we can see where we are. If they haven't made any progress, then at that point you can reassess. But I think that's why, first of all, we have colleagues to talk with. We also have experts. We have folks that have been treating the parents, or service providers who've been working with the parents. We should be talking to them. We should be talking to folks that know the child, including the relatives and the caregivers. If the relatives say, yeah, I have the 2 older brothers, well, the fact that relatives have 2 older brothers makes me wonder why the parents haven't been able to step up for the 2 other brothers. That's an indication, perhaps, that they're not going to be in a position to parent. If the 2 older brothers are 9 and 10, and the parents have never parented them, that would be something that I would take that into consideration. Talk to the relatives. Well, mom said she'd come back after 2 years. She hasn't. That would be something that I would think about. So I think we look at all the facts, we speak to everyone we can, and we get guidance from our client.
This would be a good point too, if that's a concern, to maybe ask the court to order an evaluation or a bonding assessment.
Absolutely. And I think that goes back to the gentleman in the back who said, who's filing the petition? Is it the foster parents or the department or the relatives? And say, if you go out to the home and the child is running over to grandma, throwing himself in her arms and playing great with the siblings, and the grandmother's saying to you, well, we want to have more visits, but it's really hard to set them up. And then you go over to the foster family and you kind of get a different sense that perhaps there's something weird there. Perfect time, go to court. We want a bonding assessment. We want a parenting assessment. We want to see where this child is and use that information to get that information so you're able to represent your client correctly.
Haven't you seen instances, though, for like a 3-year-old child that spent 18 months with the parents, and they bonded no matter how bad the parents are, they're still the parents, and if you were to ask the 3-year-old child who you want to go live with, they're going to say they want to go with the parents, even if that's totally out of the question.
Absolutely.
So you can't be necessarily even paying much attention to the fact that the child is saying that's his or her interest or her guiding role.
Yeah, I would disagree that you can't pay attention. If you've got a little one, even if they're 3, and they're saying, I want to be with my mom and dad, and it's because mom and dad are mom and dad, and kids are going to say that, you certainly do want to pay attention to that. The things I would consider is how long have they been out of mom and dad's care. If they still want to be with mom and dad and they've been in a wonderful foster home for a year, I'm wondering what's going on. Have we not provided enough services to mom and dad so they are in a position to care? Is there something that we can do to facilitate that relationship, to fix that relationship? Is there a reason why the child is not bonding with someone else? I would go and talk to those experts. I would get a bonding assessment. That would actually be a very strong indicator that I need to do some more research. The other thing, too, is kids are pretty good at knowing what they want and why they want it. I had a client who said, I want to be with my mom. Mom was really, really mentally ill and very, very scary. And so when my client said to me, I want to be with mom, she was significantly developmentally delayed. And I said, okay. I said, just tell me a little bit more about that. And she said, well, I want to be with my mom because kids should be with their moms. And I said, yeah. Most of the time that's true. Sometimes that doesn't happen, though. So let me tell you what we're doing. We're going to court, and the judge is going to make a decision about where you should be. And one of the things the court has to consider is what's best for you. And so, you know your mom, you know you. If you were the judge, what would you order? And my client said to me, there's no way I'm going home. And I said, okay, well, tell me why. And she's like, my mom is crazy. Didn't you see her in court? I said, I did, but you just told me that you want to be with mom. She's like, well, that's because kids have to go with mom. And I was like, but that now kind of sounds like maybe you don't want to be with mom. She's like, oh. And I was like, okay. And I said, well, what's the issue? And she didn't want to say in court that she didn't want to be with her mom because her mom was crazy, and she was worried what her mom would do. So my position for her was, Your Honor, my client very much wants to be with her mother because that's where children should be. She is currently placed in a foster home where she's doing incredibly well and is very happy there, like school. And I gave all the list of why the foster home was great, right? So mom hears, client wants to be with mom, right? Court hears, client's happy where that she is. Court orders, child stays where she is, right? So we can be creative. I think that was the duty to be creative that Robin stressed, right? Can we go on? Okay. Oops, did I go the wrong way? Okay. Post-disposition hearing. The court is going to schedule, if the court grants TPR, they're going to schedule a review hearing, which is like the judicial review or permanency hearing, 30 days after the TPR hearing. And then they're going to continue to have those reviews every 6 months until permanency is obtained. The best permanency after a TPR is going to be adoption, right? Because that's why we cut off those parental rights. But permanent guardianship can also be granted post-TPR. Okay, let's talk about the last hearing, the adoptions. Great adoptions are almost as good as really great reunifications or any other great permanency plan based on what your client wants. Okay, An adoption has to be scheduled no sooner than 30 days after the TPR was entered, or after the issue of the mandate affirming the TPR. The reason for that is we don't want to have an adoption, have the parent file an appeal, have the appeal upheld, and then have to undo the adoption, right? This would be bad. We want to make sure that we are all in the clear before we go towards adoption. Okay. Circuit court has exclusive jurisdiction. So what that means is if a court terminates the parental rights, that's the court that's going to be doing the adoption. Why? Because that's the court that knows the family, right? Knows the child, knows the circumstances. What you don't want is, the circuit court granting a TPR because it's in the manifest best interest of the child. The parents have voluntarily consented. We've got a post-adoption contact order, and then the proposed adoptive parent flies off to somewhere else, Hawaii, and gets the child adopted by someone else, right? We wanted to go to the court of origin so that everyone knows that this is what's best for the child. Who can be adopted? Anyone, including adults. So if you have a teen client who has been TPR'd and the agency says, yeah, it's too late for you to be adopted, that's not true. Anyone can be adopted. It's particularly easy as an adult if the parental rights have been terminated because the child is the adult, they can sign off on the consent and it's good to go. But anyone can be adopted in Florida. Lots of young adults can be adopted. It's fine. Okay? No one's out of luck if that happens. Who can adopt? Husband and wife can adopt. An unmarried adult can adopt. Married persons without the other spouse. That's typically in a step-parent adoption. But sometimes one person of a married couple can adopt if the court finds good cause. I've never seen that happen. I'm not sure what those facts would be, but that can happen. And then in Florida, we have the Henry Gill case, which found that it was okay for gay couples to adopt, and the state has not appealed that, so that is where we are, even though the statute has that bar. Who has to consent to adoption? The department and any child 12 or older. So if you've got a 12-year-old who does not want to be adopted, make sure that you are filing something with the court that says this child does not consent. Make sure that your child is not being asked to go to a meeting at the department. Make sure that there are no consents being signed without you being there. That being said, if you have a client who is 8 or 7 or 6 or anywhere up to 12 who doesn't want to be adopted, go ahead and file an objection to the adoption. I cannot imagine that this would ever be in a child's best interest. Everyone goes to court for the adoption day. Everyone's in their pretty dresses and their little suits, right? And the kid is like, no, I don't want to be adopted. Like, I can't imagine the court was like, well, this seems to be a really good idea. Like, I can't. So you want to make sure that the court knows that this child is objecting to the adoption for whatever reasons. Make sure that they're known. Conversely, if your client wants to be adopted, it's totally appropriate for an 8-year-old or a 9-year-old you can file something on their behalf and say that, Johnny 8 is looking forward to adoption and consents to his adoption. Again, it's about giving our clients power, knowing that they've got options and choices, and encouraging them to be part of that so they understand what's going on. I just told you that one of the consents that's required is the department's consent. If the department withholds consent, so something's happened in the potential adoptive family and the department is saying, nah, we're not going to consent. If your client wants to be adopted by that family, you can ask the court to hold a hearing to determine why the department is withholding their consent. The court is going to evaluate that and look at all evidence. If the court says, yeah, it's inappropriate for the department to withhold the consent, the court can waive the requirement of the department's consent and grant the adoption basically over their objection. Okay? Here, star again, post-adoption contact considered. Once again, children have a right to ask for post-adoption contact with family members, biological family members. And that can include visits, physical visits, written correspondence, telephone calls, pictures. It can be with siblings, and upon agreement with the adoptive parents, it can be with the birth parents and other relatives, grandparents, and the like, right? That is reduced to writing, and it becomes part of the adoption order. So it's enforceable if something happens, two families adopt siblings, one adoptive family starts to get in the way of the siblings' relationship or visitation, go back to court and say, look, we want to look at the contact. And the court can take into consideration what's in the children's best interest. Okay? Adoptions are voidable if they substantially fail to meet the legal requirements, but only within 1 year. So if something goofy happened 10 years ago, the adoption stands. If something was legally inappropriate and someone brings it back to the court within that first year, it can be voided. That's why we want to make sure that we are following the statutory requirements, making sure everyone's got notice, and that we follow that law so that we don't end up in that unfortunate position. Make sense? Okay. Questions?
I have a question going back to placement. So if a child goes into a licensed foster care provider without having an attorney, because they're not entitled to attorney, and they're being moved around all the time, how would anybody ever know or be there to advocate? I mean, it seems like they're stuck.
Yeah, they are stuck. The question was, if a child goes into a licensed foster care placement and starts to bounce from foster home to foster home, or more likely group home to group home, how would anyone advocate for the child? It seems like the child might be stuck there without anyone there to speak for them. The answer is the child is stuck there without anyone to speak with them. Federal law requires that every child that's involved in the dependency system has an advocate, either a guardian ad litem or an attorney. Florida is not in compliance with that. There are lots of kids that aren't assigned a guardian ad litem. There are lots of kids that don't have a guardian ad litem to speak with them in court, and the role of a guardian ad litem is significantly different from a role of an attorney. So even if they do have a guardian ad litem, sometimes that guardian, what the guardian believes is in the child's best interest is not what the child believes is in their best interest, and maybe in conflict with what their legal interests are as well. So that's why we have programs like this to start to recruit attorneys. What I have found is I represent a lot of kids that are in group homes. And when I've gone out to the group home and to talk with my clients, and then something happens good for my client, the next time I go out to see my client, her roommate is sitting there and says, can you talk with me now? And sometimes kids have hired me on their own and said, can you file a motion to get appointed to my case? And I do. And one of my factors is, the child has requested representation. I can represent the child. Please appoint me. And so, that's one way to do it. Unfortunately, because there is no statutory mandate or guarantee, the question is, where do you find an attorney? How do you know the attorney is qualified to represent the child? And if you don't find, who pays for that attorney? And there is no uniform system around Florida yet because it is very much hit or miss. Robin's organization, the Florida Children First, they did a very nice overview of representation around the state about the numbers of kids that are represented, access to attorneys, how many attorneys are, and it's incredible that your well-being and your life can be impacted on which county you happen to be abused and neglected or abandoned in. It's unbelievable.
Getting back to, getting into a case for a kid, who can move, can the parties move to, can the parent move to get the child representation?
Yes.
Okay.
Any party can request that the child get an attorney. The state's attorney can request that the child have an attorney. The parent can request. The guardian ad litem can request. The child can request.
Any party, what about participants?
You know what? I think if a participant asks, the court would consider it. Yeah, and if there's a child that needs an attorney and there's a participant who's there on behalf of the child and they think that, my recommendation to them would be ask loud, ask often, make moaning noises. I mean, one of my favorite things is if you ever watch Shelters early in the morning and the court says, parties approach, this, I'm in Pinellas, the state's attorney approaches with the CPI and the case manager, and then the parents approach with their attorneys, and then sometimes the guardian ad litem will approach, the guardian ad litem attorney will approach, and then there's this little tiny kid who's like, and I'm like, oh, it drives me crazy that they're there by themselves. And again, as I mentioned earlier, shelters are huge, and it's shocking to me that the child isn't heard from or isn't represented. And I come from a state where kids got attorneys from the moment a shelter petition was filed, and I regularly overturned a shelter order and got kids to go home. And so I know it can be done.
I'm just curious what the rationale is behind typically appointing a child's attorney
I actually don't know what the rationale is. My thought was that children should have attorneys from the get-go. I think what happens is when children are in foster care for a long time, we suddenly realize that the system is not working so well for them, and perhaps they do need an advocate. Would be all of a sudden all hell is broken loose, and people are like, ooh, maybe this kid needs an attorney. And that might be why folks begin to think about it then, or when folks get stuck and they're not sure exactly what to do. The other thing is sometimes what will happen is, and I've had this on cases where the guardian ad litem will be recommending something and the child will be in a position where they say, that's not what I want at all. And then the guardian ad litem will say, okay, well, I'm going to be representing something that you don't want. We need to get you an attorney so you have your own advocate. And that's the right thing to do.
And I feel like a lot of times an attorney ad litem won't get appointed if there's a guardian ad litem. And so we get appointed later also if a guardian's appointed and then they find out there's a conflict or they don't have the resources to have a guardian, and then it's months down the road and all of a sudden they're like, oh, you can't do it now? Okay, well, let me ask.
Right, and sometimes the answer was sometimes an attorney won't be appointed when the guardian is already on the case, and that's correct. And then later on, the guardian gets off the case because of a conflict or something else is going on, and then the court will say, well, we need someone for that child. And I think that's right. And sometimes I think it's also because the issues that the young person is facing have the child has legal issues that the child needs legal advice, and the guardian ad litem can't provide the child with legal advice. Nor should a guardian ad litem who's not a lawyer be providing a child with legal advice. Any other questions?
What kind of is interference from like the appointed, like the sheltering, if there's like a sheltering family member, or if there's somebody in line for a guardianship or adoption? Is interference from that party common with access to kids? I can see where there could be issues there.
That's a great question. The question was, will the caregiver of the child sometimes interfere with your ability to access the child? Yes, that can happen. I have not had that happen very often. When that does happen, you need to be creative about where you meet your client. And it could be that you say, all right, to the case manager, are you picking up the client for anything? Can I meet them there? Or will you bring them to court? I'll meet them at court. Or sometimes you might go to school and meet the child at school. My favorite story, I had a nonverbal client who came in to see me at my office, and he walked in, and I swear this kid could not speak. He walked into my office and he said, "It is in my best interest that I live with my grandmother." And I can't imagine how long the grandmother had practiced with him to get that sentence out. Because I would say, what's your favorite color? And he'd say, he couldn't speak. He really couldn't speak. But he got that entire sentence out. And I was like, good job, buddy. And then I waited 2 weeks and I went to go see him at school. It was amazing. And I thought, wow, they must have worked so hard on that. And all that told me was Grandma really wants the boys to stay with her. That's all that told me. It didn't tell me anything else. Yeah.
Is there a good resource that explains how the finances should work for kids who are in a foster home? Like, I think they're supposed to get an allowance. I'm not talking about the special trust situation, but outside of that, is all money funneled through the foster parents?
Yes.
Especially for teenagers.
Yeah, that's a great question. The question was, is there some place where we can look to find out how much pocket money a young person, if they're in a licensed foster home, should be getting? And the answer is yes, sort of, maybe not. Every foster parent goes through the licensing procedure, and they have requirements about what they're supposed to be providing for the child. I think the current rate of foster care pocket money is an egregious $15 a month. I'm not sure exactly what a young person is supposed to do with $15 a month. I don't even think that covers a movie ticket. So they can save up for 2 months to go to a movie, I think. But it also specifies what the foster parent should be providing for the child. If the child is in a group home or in a therapeutic foster home, those agencies have contracts with the DCF which specify what the allotment of money should be covering. It does say that pocket money shouldn't be used to cover necessities, personal hygiene items, things that are school supplies, things that are required. And you can certainly, there's nothing wrong with saying, we need to have a meeting about how you're going to spend your money, or what money this child is getting, or where does my client get her school supplies from? What's that going to look like?
We actually do have a publication we call Know Your Rights Money that's on the Florida Children First website that talks about the right to work allowance, money coming in from Master Trust, and explains that, individual savings accounts. So those, that money book is available, and you can print copies for your clients and as a resource for you. The current allowance, and I just looked at it again recently, was set under Secretary Carney. It's $10. My infant foster son got $10 a month allowance. A teenager gets $15 a month allowance. They get $11 a month for incidentals. The foster parent does, and $35 a month for clothing. $45 for teenagers. But, and I'm a licensed foster parent. I know this because of my job. If you, the foster parents don't know that. They just get $430 a month for a little kid. So unless someone reminds them what that money is for and that the child is supposed to get allowance, they don't know what that amount is. In South Florida, a lot of times they'll give the kid the 15 plus the 11 plus the 45, and then they're responsible for everything on their own. So it's implemented differently. Many of the group homes don't give their kids allowance. They are supposed to. You can demand it, and they are required to provide it.
Are the foster homes required to do any accounting or any showing what they do with that money that's actually earmarked?
Foster homes are supposed to keep receipts for the $300 a month back-to-school clothing allowance and keep it in the child's resource record. Yellow Jackets in Tampa. But if they are spending child's money from master trust funds, they are supposed to keep the receipts for that.
But not for the monthly allotment.
No.
And all of that money is separate from what I hear about regarding ad litem, like the teen wrap money that goes, do you know what I'm talking about? Some money that buys like sort of larger items for older teenagers
There,
in foster care.
I don't know which pots of money that they're accessing. There are some pots of money though that they can tap into for older kids.
Everyone good? Thank you very much.